All right. What up, perps? How's it going? Uh didn't get to stream these live today because work. Um, but we're gonna do it now. Uh and I think I'm gonna do like I've done before. I'm gonna let him stream through clean without me saying anything. You might see me in the background wanting to bang my head against the table. But I'm gonna let him play through once, just clean without commentary, and then we'll run back through them if as long as you guys want to hang out. We'll run back through them and actually pause it and talk about stuff as we go. Uh, Blue Curtain says so many ATF 2A cases right now. It's a glorious time. It is, man. As long as we can get these things to fall our way. If we can, if these courts will go by the law, we're going to every single time. But you guys already know how that goes. We've listened to other oral arguments where the judges are basically saying we don't give a shit what the law is. We're just going to rule like we want to. So, but it's real cool because you got kind of a balance right now. You got a lot of stuff going on in the courts. Supreme Court taking up cases. I believe those will go our way, but I don't have a whole hell of a lot of faith in it. But then we've got states out there right now that are pushing gun control like it's fucking free. Minnesota, I was checking on some stuff earlier today. A couple guys I follow on X and I follow them on YouTube too, have already put information out. There's supposed to be some gun control bills pushed in Minnesota today. I believe it's today. Don't know what's going on in Colorado right now. Colorado's go with gangbusters on gun control. And Colorado, Minnesota, Michigan's going. They've absolutely lost their fucking minds. And there's a couple other states that I'll have to go back and look. And hell, if you guys saw, when was it? Day before yesterday? Yeah, even Alabama's pushing shit. And now we got this retard senator who wants to do away with constitutional carry, but I don't see that coming up till next legislative term. So we'll see how all that runs. So anyway, baby, if you're still in the chat, I love you. I'm home, as you can see. Still working, doing shit, but it's been a morning. So we're doing this now. Blue Curtain, what is up, my brother? So let's get to it. Like I said, I'm going to mute myself. We're going to let this play through. And I got this video, downloaded this video. Hopefully I can get this thing to play through smooth. You guys let me know about the audio when I start playing. Let me know you can hear it okay. Let me know that the sound's good. And we'll see whether we can go through this without me absolutely losing my mind. And for those of you who don't realize what this case is about, Texas basically put in a law that said if our people are going to make suppressors in Texas that aren't going to be for resale, they're making them for themselves, therefore they're not traveling in interstate commerce. And if they're not traveling in interstate commerce, then the ATF can't do anything with it because the entire NFA is based on the interstate commerce clause. So this will be an interesting. I've heard bits and pieces of it today while I was dealing with a bunch of shit at work. I haven't been able to listen through the whole argument clean and actually been able to concentrate on it. So that's what we're going to do this first time, and then we'll pause it. We'll talk about it. Hopefully, you guys throw some stuff in the side chat that catches your ear in this, and we'll talk about it more from there. So let me mute my fat ass and.
On during argument, we ask you to wind down.
Hold on, not yet.
Your presentation.
You guys, give me a 5x5 on the sound as long as sound's coming through good.
Unless the court has a question for you. We are also familiar with the briefs and record excerpts. We have not necessarily read the record, and we appreciate record citations when those are applicable. With that, we call the first case of the morning, number 23-10802, Paxton v. Dettelbach. We'll hear first from Mr. McDonald.
Good morning. May it please the court. My name is Tony McDonald. I'm here on behalf of the individual plaintiffs, and Mr. Eldred will be up to talk to the state's interest in the second half of this presentation. I'm joined by Mr. Martin, Tracy Martin, who's one of the three individual plaintiffs in this case. They've testified that they wish to make a simple noise suppression device in their own homes with their own skill, with their own materials. But unlike the mufflers that are attached to our cars and our lawnmowers, they want to attach this device to their firearms. Mr. Martin would tell you that he believes every home defense weapon should be suppressed, not only because it protects the shooter's hearing, but it makes them more attuned to the threat, to know when the threat is eliminated. The plaintiffs here seek to make these devices, they wish to make these devices, and it's not disputed if they were to go home and make these devices without seeking the federal government's permission, without registering the devices, without serializing the devices, and without paying a $200 tax, if granted permission to make the devices, it's undisputed that they would face 10 years in prison. Mr. Martin could leave here today and he could proceed with this course of conduct to make these devices without seeking the federal government's permission, and he would face 10 years in prison. That's not disputed. The Supreme Court in Babbitt has told us that a course of conduct, when a plaintiff proposes a course of conduct that is arguably affected with the constitutional interest, that is prescribed by statute, and where there is a reasonable fear, here there's not just a fear, but a confidence that there would be a prosecution, that those plaintiffs are not required to break the law in order to test the law.
Well, they're not required to break it, but the reality is they've got to do more than just wish. They've got to do more than express some ephemeral desire to do something that might run afoul of the law. What do you have in the case besides their declarations?
So I would challenge the premise slightly. I don't disagree with you. What we have is sworn declaration testimony that these plaintiffs wish to proceed in the course of conduct that's prescribed by the law.
Well, how far do they have to go? If this were a First Amendment case, and the plaintiffs wanted to parade without a permit, I assume that a declaration only would have to say we're planning to parade and we think a permit is unconstitutional, so we're not going to apply for one. Would that be sufficient?
Well, that would be, and I will say the First Amendment context, there's relaxed standing. That's not clear in the Second Amendment context. But what Babbitt tells us is that there's a general rule which says you propose a course of conduct that's prescribed by law that's subject to a reasonable threat of prosecution. Then the court looks at instances where that proposed course of conduct is imaginary or speculative. And so that's how we take care of cases in which there are contingent things that might happen or might need to happen in order for there to be standing. Here, there's no contingent thing. Mr. Martin could, like I said, could leave here and could travel to his home and begin the process of making a firearm suppressor.
Well, look, you have limited time, and we understand that, but the nub of it to me is, do they have to allege precise facts about, I've already bought a 3D processor, or I already have metalworking equipment, I have the knowledge, I know where I'm going to buy my supplies for this. Exactly how much would suffice, number one. Number two, if you are challenging the regulatory regime, our court just issued an opinion, a couple of opinions that say that being exposed to a regulatory regime that is arguably unconstitutional is injury.
That's right. I think you're speaking, Cochran and Axon Enterprises went to the Supreme Court. A plaintiff is found to have standing to challenge an administrative regime that they say is unconstitutional. They don't necessarily have to go through that process in order to do so. So I think that is instructive, although obviously a bit different in this context. To your question about a proposed course of conduct, the plaintiffs have alleged that they intend to do this action, which is really quite a simple action, in their own homes with their own materials. There has really been no factual dispute about that. And we actually were working to develop a factual record in the trial court, and the trial court said, we don't think discovery is needed. So to the extent that there was a dispute to say, well, these plaintiffs are not capable of doing this relatively simple thing, that's something that really should have been developed in the factual record. There's nothing more that these plaintiffs could do other than say, in sworn testimony, in a sworn declaration, sending that to the Attorney General's office, hiring an attorney, and bringing a lawsuit to say, I intend to engage in this course of conduct.
Well, right now, you are also challenging the regs that say we want photos of every single component, right? And not just the tax, but we want, basically all your background information. So you can file an application that we may or may not grant, and if we don't grant it, we may, because you've sent us incriminating information, we may prosecute you, right?
Well, and that is a factor. So,
well, is that part of the basis for your claim of standing?
I don't think it's necessary, but it is helpful. The unique circumstances here show additional reasons why they're standing. So to add to that, there's an application process, but what we have alleged in this lawsuit is that application process is being used to abusive ends. Some applicants are being made to wait indefinite periods of time that the ATF has been asked.
Well, we can't, how could we adjudicate that unless you had actually applied?
I disagree. I think the question is this process applied to this exercise of this right?
What do you do with the case law that says silencers are not protected under the Second Amendment because they're not firearms?
Well, I think it's premature for this court to reach that question, but I think it's wrong.
There's case law to that effect, correct?
There's district court cases, non-binding cases, but the U.S. Supreme Court has told us in Heller, in Bruin, they describe arms as articles, modern instruments that facilitate self-defense. It's a very broad definition for what an arm
Well, we're going to find out what they say about Bruin, I guess, shortly, and Rahimi, but still, you've got where's the case law that says a silencer is protected under the Second Amendment?
There is no case that says a suppressor silencer is an arm. That's a question that I think ultimately may get to this court. I don't think it's primed for you to rule on that today. I think that's to the merits of this case as opposed to whether we have standing. But these are the answers that this case is meant to provide, and these are the questions that we're trying to ask the trial court to answer.
Okay, you have a chance. Well, thank you.
Thank you.
Mr. Eldred?
Thank you, Justice Jones. May it please the court, I'm Charles Eldred for the state of Texas. As applied to citizens making firearm suppressors for non-commercial personal use in Texas, the challenge statute and rules affect Texas's quasi-sovereign interests, and therefore Texas has standing also to pursue this case. According to the Alfred L. Snap opinion, quasi-sovereign interests consists of interests the state has in the well-being of its populace. They also say it's a quasi-sovereign interest in the health and well-being, both physical and economic, of its residents in general. And importantly, this is an interest apart from the interest of the particular private parties. So this is not a parents patriae case. The Mellon bar does not apply. Mellon v. Massachusetts, as recognized in Massachusetts v. EPA, specifically said that this is not a case about quasi-sovereign interests. Quasi-sovereign interests are the kind of things that states can bring on their own behalf, again, to vindicate the health and being, both physical and economic, of its citizens, residents in general.
Let me ask you, does Section 2.052A of the Texas Code, does it do anything beyond exempt the suppressors made in Texas from federal law? Does it
I don't have it
any
in
other
front of me, but
function?
I don't think the law is, what the statute is intended to do is not to let, say, a citizen's make the suppressor and then go to federal court and say, ha, I've got this law that says I don't have to do it. It does not exempt citizens from the operation of federal law. It sets up a sovereign interest in Texas is a sovereign interest in having citizens make these things. And this is what the law does, and it tells us the Attorney General to come to court and try to vindicate that sovereign interest.
What is the sovereign interest?
Sovereign interest is Texas's interest in having its citizens be able to make suppressors for non-commercial personal use for self-defense.
How is that a state sovereign interest?
It's sovereign interest because the code says so, because Chapter 2 of the Civil.
So you're proceeding under the theory that Texas can enforce its code.
I wouldn't put it that way.
Are you not proceeding under that theory?
Am I proceeding on the theory that Texas? Well, the code doesn't do anything other than order the Attorney General to file a lawsuit.
Well, that's sort of what I'm getting at, back to Judge Clement's question. I mean, I'm struggling to find what sovereign interest Texas has that's distinct from the individual plaintiff's alleged interest in rights.
Well, two answers. The quasi-sovereign interest is defined as
Quasi-sovereign is different than sovereign. I'm trying to get at what the sovereign interest of the state is.
that's the sovereign interest to create and enforce a legal code. Yes.
But you basically have said that the legal code here just says we're contrary to federal law, and the Attorney General needs to bring this action.
It does say that. That's true. It is a clash. It does set up a clash of sovereigns, though. We say the statute says, our legislature says that we don't think the federal law is constitutional, and they want this Attorney General to do something about it.
Yeah, but the state can't set up a clash of sovereigns by passing a law that says we disagree with federal law.
There are cases out there that say that the state can't pass a law, can't create a sovereign interest just by saying, "Hey, citizens, you don't have to comply with federal law." I agree with that. I just don't think that's what Chapter 2 does. It's a different.
What else does it do?
It tells us it sets up this very lawsuit, which is a different thing than just saying citizens don't have to comply with law. Chapter 2 does not say citizens don't have to comply with the law.
We can set up a lawsuit to allow the state to come in and say citizens don't have to comply with federal law.
That's what Chapter 2 does, yes,
I
sir.
think we're completing the circle. What about quasi-sovereign interest? How are the state's quasi-sovereign interest here distinct from what the citizens would bring as individual claims?
They're distinct mainly because the Supreme Court has defined them as distinct.
But no, I think the state has to articulate some distinct quasi-sovereign interest in order to proceed as a plaintiff, does it not?
Well, I think we have. It's the interest in the health and safety of our citizens.
But you can't just generally say that and proceed to intervene as a plaintiff or stand up as a plaintiff in the lawsuit. How are the quasi-sovereign interests of the state of Texas affected, distinct from what the individual claims are?
Well, because it just, I don't know how else to say it. It's just defined as the state's interest. The interests are similar. They overlap a lot. The citizen has an interest in his own health and safety, but also the state has a separate interest in the citizen's health and safety according to the law.
Yes, but that doesn't give the state the ability to intervene in every case where a plaintiff's health and safety are implicated, does it?
Every case? I don't think so, no.
What's your best case to support standing here?
Probably Massachusetts v. EPA, which they said was a quasi-sovereign interest case. That's the case, of course, that kind of set us up down this path of all these lawsuits being brought. I do want to say one thing about...
What do you do about Missouri v. Biden? Didn't that cut back on Mass v. EPA? Isn't that the one? Well, I get them all confused now, but it was the one about immigrants, about the requirement of the alleged requirement of the federal government that it shall remove criminal aliens.
We call that the prioritization case. In that case, they found we had no standing because there is no standing ever to order the federal government to arrest people. The federal government has authority or discretion to arrest people or not.
So that wasn't a direct challenge to Mass v. EPA?
No, I don't think it was a direct challenge to that. If I can squeeze in a little bit about the Anti-Injunction Act, I will acknowledge that our reply brief is incorrect when we say it's not before you. The other side raised it, but it's not supported by the record. I see my time is up.
Okay, you have a chance for rebuttal. Mr. John Doe?
Thank you, Your Honor, and may it please the Court. Sean Janda for the federal government. The district court correctly held that no plaintiff has established standing to challenge the NFA's restrictions on making silencers and dismissed plaintiff's complaint without prejudice. This court should affirm.
Suppose, what would it take for plaintiffs to have standing to challenge? I mean, I don't understand how the government can promulgate a regulation that says, show us photos of all the stuff you're going to use, and if in our discretion we deny you a license, the FBI is going to be at your door tomorrow. In other words, how can the government require self-incrimination, potential self-incrimination as a basis for regulation?
So I think that's just absolutely not what's happening here.
It's not, but it could.
It could not, and here's why. 26 U.S.C. 5822, which we cite in our brief, says that no information that is provided in an application under the NFA can be used directly or indirectly in any sort of federal criminal proceeding, other than
a database, isn't it?
I'm not sure what happens with an application that's denied, but the statute makes very, very clear that the government cannot use that information to prosecute.
Well, the government couldn't target conservative organizations, but the IRS did. The government couldn't target other specific people, but the government, it happens.
I mean,
The question is, could they file an incomplete application? Could they file an application, have it denied, and then would they have standing then?
yes, they would absolutely have standing if they
Gave a more detailed declaration where they described what they intended to get, maybe identified the components in a little more detail. I mean, where is the line after which they have standing to challenge these regulations?
Yes, so I think the very easy case would be if they applied and had the application denied or granted, and they paid the tax.
Well, if
and that
you
would give them
just sit
standing.
on it for the next 2 years, of course, then their ability is thwarted, so.
I mean, I think at the point that they've submitted the application, if they think it's been constructively denied or they think there's a problem with the delay because they think they have a Second Amendment right to not have to go through the process, I think at that point they would have standing, and there might be other threshold problems, but they would certainly have standing. But at this point, they haven't submitted an application, and even to turn to the declarations, I think the declarations in this case are just the absolute bare minimum that you could possibly have. They say that the plaintiffs intend to make a silencer, and there's just no additional details. And so I think the sorts of things that this court identified in Barber would be the sorts of things that the plaintiffs would want to put in a declaration that would get them closer to that line. So any concrete steps they've taken, for example, they say that they have some intent to make the silencer with components made only in Texas. If they went on to say, we've taken the steps to identify particular components that we know are made only in Texas, and these are the ones that we sort of have purchased or would like to purchase, or would purchase if we were to win this lawsuit, I think that would help them a lot. If they had any additional information about the silencer design that they would like to make, the tools that they have that would permit them to make the silencer, any sort of training or experience.
Are you conceding that that allegations of these facts would be sufficient such that if they file another lawsuit, the government will concede standing?
I don't think I'm in a position to say that any specific alleged fact would be enough. I think the court really would have to look in any future lawsuit at the constellation of facts.
We keep records too, and you do concede that there are these kinds of facts that would certainly be sufficient for standing.
I think each of those facts in a declaration would get them closer. I don't know exactly where the line would be. If they filed an application, they would have standing 100%.
You agree they don't have to do anything to violate the law before they have standing for a pre-enforcement challenge?
Correct. If they file an application, if they provide the information in the application, and if it's denied or if it's granted, they have standing.
So what would sustain a pre-enforcement challenge in your mind?
So I think in the NFA context in particular, it's a little bit tricky. I mean, this court's cases, and I think Westfall is the most complete on this, I think impose a pretty high requirement here because there's no risk of having to violate the law to bring the challenge, which is sort of the basis for the exception to the normal rule that you have to be injured before you can sue. And in this context, you can establish standing without ever violating the law, and you can bring all your challenges at that point. And so I think, you know, Westfall read to its extremes, it might say really the application is required, and no amount of additional concrete steps would be enough, short of filing the application, which again doesn't violate the law, would not expose anyone to prosecution.
No, well, you've got to have photos.
So you don't have to have photos. The relevant statute says you have to describe the firearm. In some cases, ATF has asked for additional information to help it make the determination it needs to make about whether making the firearm will put you in violation of federal law.
At that juncture, wouldn't the plaintiffs then have standing to come in and say, we applied for this, we don't think we have to violate the law, we have been injured, and we have standing?
Yes, absolutely. If they applied, if they got that follow-up request, if they didn't want to comply with the follow-up request.
And that would be sufficient at the summary judgment stage.
Yes, I think having filed the application, they would have standing. There might, as I said, be other problems. I mean, I think the Tax Anti-Injunction Act might cause them difficulty if they didn't actually wait for a decision on the application. But I don't think that would be a standing problem. As soon as they filed the application, we think they would have standing. And again, as I said, we read this court's cases as really thinking or saying that the application is required in the NFA context. But I think even outside that special context, I think Barber is a really good example of the sorts of things that the court would usually look for, just none of which are present in this case. So any of those additional facts, I think, would certainly help the plaintiffs. And as I said, the district court dismissed the complaint without prejudice. There would certainly be no procedural barrier to them refiling the complaint, including additional declarations, evidence of the sort that we've been talking about. And then, if the court has no other questions about the individual plaintiffs, I think just turning really briefly to Texas's independent asserted claim to standing, I think the fundamental principle that we divine from the Supreme Court's cases is that a state cannot bring a lawsuit against the federal government if the state is really asserting the interests of its citizens. And here, I think that Texas is just saying they would like to assert their interests.
Well, what was the interest asserted in Massachusetts versus EPA?
So there were two interests, Your Honor. I mean, one, the substantive interest was that, Massachusetts' view, part of the
water was going to rise.
Right. I mean, part of the state was going to be submerged. I mean, that's a
which of course, 30 years after the fact is demonstrably untrue, but that was good enough for a hypothesis, right?
I mean, I think the interest there, or the claimed injury there, and whether or not that injury was borne out or not, I don't know, but the claimed injury was that part of the state was going to be submerged. I mean, I think that's a pretty core territorial.
Well, tell the Obamas that.
And then I think the other thing, Your Honor, is that there was also a procedural component to the interest there, which was that Massachusetts had filed a rulemaking petition in that capacity to vindicate that substantive interest, and that rulemaking petition had been denied. And so here, there's just none of that. And I think that the footnote that they rely on in Massachusetts says very clearly, and maybe the only very clear thing in that footnote, is the state cannot sue to assert its citizens' interest in avoiding the operation of federal law. And that's just exactly what Texas is doing here. They think their citizens in this context shouldn't have to comply with the NFA. And again, whether they're right or wrong about that, that's a claim for their citizens to bring, and not a claim that they get to bring on behalf of their citizens. And then just, I think the final piece of it is, I don't think enacting a state statute that sort of codifies the litigating position that.
Well, what about all the cities that pass laws, or states even, proclaiming themselves sanctuaries?
I mean, I think you can pass whatever law you want. I mean, we don't have any problem with Texas choosing to codify its litigating position. I'm not sure that.
Well, they all litigated against the government. Some of them did during the last administration.
My memory, Your Honor, and I'm not 100% sure about this, so with that caveat, my memory is that in that litigation, there were grants that the federal government tied to cooperation with federal immigration enforcement, and that was really the underlying interest. And so it wasn't just sort of the bare interest in proclaiming a disagreement with federal law, which I think is all we have here. I mean, the NFA, in relevant part, doesn't require Texas to do anything. It doesn't regulate Texas. And so, Texas can pass the statute, but I don't think they can leverage the statute to create standing where none would have existed otherwise. So if there are no other questions, we would ask that the court affirm. Thank you.
Okay, Mr. Eldred.
few things. I believe the ACF's position is that they can use the information that is provided to deny the application. So if you send them pictures of your parts of a suppressor, they can say you're already violating the law because you already own a suppressor, because the parts of the suppressor are defined as a suppressor under the law. So if you send the pictures of parts,
But if plaintiffs have that fear and they make the application and they don't send a picture of the parts, they've applied for a silencer. They could even state on the application, we're not sending pictures because we don't want to run afoul of the law. And then when the government denies the application, have they not then suffered an injury?
I agree with that.
Counsel opposite just said they would.
Well,
There wouldn't even be a dispute about standing if they just filed that application I just described.
I agree. I think we agree with that one. But we do think that the application itself is the injury. I mean, imagine if you had to apply to discuss the election in your own home. This is different than the parade example. This is a.
But you just, I mean, I think you just gave away the game, did you not? The application is the injury. The application is not legal or illegal, and filling out an application is not legal or illegal. It doesn't subject you to any criminal penalties, but it does subject you to an injury because you've got to have filled it out. But they haven't done that here. No injury, no standing.
Well, we're saying that this is a case where you can sue before there's an injury.
I understand pre-enforcement, but still, you have to have some threat of injury or something that's substantiated before you can just come in and say, well, we'd like to do this, and so therefore we're going to sue.
Our count one is we want to be able to make firearm suppressors in our own home for non-commercial personal use without doing the application, and that's the difference, I think. It's similar to what I was about to say about needing to apply for permission to speak about the election in your own house to your own family members. If that was a law that said you had to do that, it would be easy to say there was standing. But you don't have to apply for permission to speak. Second Amendment law, of course, is developed because Bruin's pretty new, but we think the same issue. If you have to apply to make a suppressor in your own home, again for non-commercial personal use, not even to take out of the state, they have to stay in the state. We think is what the statute says. That is very similar, I think, to applying for permission to speak in your own home because there's no time, manner, or place restriction. There's no imaginable reason why the government can do that if you have a right to bear arms.
What's the, what is the statutory and constitutional basis for the challenge to the regulation? It assumes standing. What is your claim? What is the plaintiff's claim? Does the regulation violate the APA? Does it violate the Constitution? What's alleged?
The Constitution, and also the rules violate the APA.
The APA. And these are procedural rules because they're licensing rules, so it's a procedural regime.
To that extent, yes, they are procedural rules, and that's been defined as a quasi-sovereign interest as well. Texas has an interest in challenging procedural rules.
Well, and the plaintiffs have, again, we do have cases that say the being subjected to an illegal regulatory procedural regime is injury sufficient for standing.
Yes, and we're saying that too. And,
what's your best case for that?
Exxon, I think.
Oh, AXON?
Yes, if I'm pronouncing it correct.
All right.
Just one more thing on the sovereign interest. The statute, we would say, a better answer to what I should have said before, it promotes the building of firearm suppression, so making of firearm suppressors by citizens for their own use. That's the sovereign interest that it implements. And I think there's no other questions. I'm done.
Okay, I think we have your argument. Thank you.
Thank you, Judge.
Cases this.
Okay, now let me unmute my fat ass mouth because we got shit to talk about. So that was first playthrough, playing them clean, letting everybody hear the arguments. It's like some tornadoes are headed my way. Alabama and Texas. Oh, God, I hope not. I don't need any tornadoes running my ass over. Thanks for the heads up, though, War. I'll have to look. So I threw the link to the oral arguments in the chat if you guys wanted to clip them or use them in a video, or if you guys wanted to talk about them or listen to them again, whatever you want to do. They're up there. This all came from the Fifth Circuit today. So, and we're going to listen to them again, where I'll pause them and actually talk about some things, but I want to hit a couple points first. One, and we heard this argument all throughout this entire case, or this entire oral argument, about standing. Courts love to throw cases out and tell people you haven't been harmed yet, you don't have standing. That's part of the arguments from today. Notice the guy for the Fed is arguing they haven't been harmed, they don't have standing. It should not be this hard to challenge an unconstitutional law. It shouldn't at all whatsoever. It should just be a simple person, whether they write their own brief or whether they get with someone to write up a brief and they send it in, they say this law is unconstitutional. They basically put their analysis of it in there, and then it should roll through. So it should never be this hard to challenge an unconstitutional law. Remember, we're dealing with not only the APA, the Administrative Procedures Act with this, we're dealing with the NFA, the 1934 NFA, where suppressors, silencers, whatever you want to call them, I'm not getting into that fucking rabbit hole, but that's where they became regulated. In this set of oral arguments, the judge asks about silencers. How can you argue under the Second Amendment if suppressors, silencers, aren't firearms? Okay, if they're not firearms, then why the hell does the ATF get to regulate them if they're not firearms? That would have been my automatic question to the judge, which would probably get me thrown out of court. But that would have been my question. If it's not a firearm, that's like the ATF regulating my truck. It's not a fucking firearm, but so why do they get to regulate it then? You just gave away the whole thing. It's not a firearm. The ATF doesn't get to regulate the shit. And this is just my scribblings. And remember, this was about people in Texas being able to make a suppressor that doesn't travel in interstate commerce, that's not being sold, that's not being transferred. Someone making a suppressor for themselves is what these people say they want to do. We hear arguments in here about, well, they haven't been harmed yet. Well, what's the harm? Well, hold on. Wait a second, dickhead. Part of what we deal with from the ATF was their change on what Form wants to build a suppressor, 2 years ago, 3 years ago now, maybe a little longer, where the ATF said, no, wait a second. These fluid traps, the shit you guys are ordering, nope, you can't use those anymore, because if you have a tube that's threaded at both ends already, that's a suppressor part. If you have freeze plugs or whatever you're going to use for your baffles, those are baffles, those are suppressor parts already. So you have to send us basically pictures, a diagram, all the information of what you're going to use to build this suppressor, and then we'll okay it or not okay it. But if you have suppressor parts, you're breaking the law. We're going to come get that from you. And if you don't give them up, we're putting you in jail, prison. It was even talked about, and I'll have to go back and look at it. It was from Prince Law Firm, where they received a response from the ATF on some of this stuff, and the ATF was going to go back in to the NFA registry and retroactively deny people using fluid traps or what they said were precursor or already suppressor parts. I haven't been able to find a lick of nothing about that since then. Matter of fact, I mentioned it on a video from Washington Gun Law probably a month ago. Because in that letter from Prince, the ATF says that they were going back into the system and were going to retroactively deny forms that they had already approved, people had already paid for, already built the shit. The ATF says that. So fuck all with that. when we're dealing with anything as far as federal gun control, you're dealing with the Interstate Commerce Clause. And that's part of what the NFA, you have to understand, we got to go all the way back. The NFA was a taxing law, and the only way that the government could tax these things is if they had traveled in interstate commerce. That was the power they were using. If you look at federal gun laws now, a lot of it's based off the Interstate Commerce Clause. It has to travel in commerce, interstate. What Texas is saying is these haven't traveled in interstate commerce. These people are building them in Texas for their own use. They're not being sold outside the state. And the state's basically going to argue two things here. One, that, well, a couple things. One, they're going to argue that the government always wins and you guys can just go fucking eat a dick. Government's always going to argue that. It's the way they always argue. Two, they argue the guys don't have standing. Then they'll argue that these precursor parts these people are using did travel in interstate commerce, or the equipment that they used did travel in interstate commerce. It's all, you guys have heard me say it before, and maybe I'm feeling a little bit extra spicy just because of my morning. The government always argues these cases as you can go hide and fuck yourself and you go first. So the Constitution doesn't matter. The constitutional restraints on government power don't matter. It is whatever the government wants to do, they justify through the most insane reasons possible. P320 is a machine gun if you toss it downstairs. That's highly likely. You guys remember the scene? Did you ever watch what was that movie with Arnold Schwarzenegger, where he was a spy? Jamie Lee Curtis or whoever dropped the Uzi down the stairs, and every time it hit, it just started firing and continued to fire. Yeah, I can see that. True Lies. That's what it was. Took me a second. Now, limits on the Second Amendment. Limits on the Second Amendment should be about like the limits on the First Amendment. I can do whatever I want. I can say whatever I want. I can say it wherever I want for my First Amendment, as long as I don't wrongfully deprive someone else of life, liberty, or property. That's the same limits on the Second Amendment. I should be able to carry what I want, how I want, where I want, anytime I want, as long as I don't wrongfully deprive someone else of life, liberty, or property. If someone thinks I am wrongfully depriving them of their liberty or their property, that's why we have civil courts. Bring that up in civil court. Oh, I'm missing patrons in my restaurant because this dude's carrying a fucking rocket launcher. Okay, can you prove that that was actually scaring people away from your restaurant? If it is, that's civil damages. It's the way that should be. Hey, Warsaw, don't put it past them, brother, because you know the ATF already decided that a shoelace was a machine gun. And I'm pretty sure they have decided in the past that a rubber band was a machine gun. Pretty sure. I know the shoelace 100%. That was a bunch of bump fire stuff, but I know the shoelace 100%. I'd be willing to bet money on the rubber band. Yeah, dude, there's so many ways to screw with the action of a semi-automatic gun to make it run full auto. Not necessarily the most reliable in a lot of cases, but it's not that hard. Depending on the firearm, probably not all that safe either. So take that as it is. So anyway. Nobody answered that. Yeah, well, you know, we got a habit of like really saying stuff in here. So anyway, we're gonna go back in. We're gonna listen to these again because it's, and I don't know how you guys are. So typically, like for a set of oral arguments or something like that, I typically listen to them a couple times, and damn near every time I listen to them, I pick up something that I didn't pick up the first time, because you kind of get locked in on a thought and you miss a couple of things, and you get locked in on a thought and you miss a couple of things. So that's kind of why I like to do them this way. Listen to them all the way through clean, just me in the background wanting to, like, you know, hit myself in the head with a hammer, and then go back through and listen to them when we can pause it and everybody get in on the conversation. So that's where we're headed now. Warsaw, all I can recommend is at least get a happy ending with the massage. That's my personal recommendation. I hear there are plenty of places you can go to do that. All right, so we're gonna play that. We're gonna play this through again. Stop it, comment on some stuff as we go. Yeah, for $200, Warsaw, you better be getting a happy ending.
Morning, but we also have a timetable. So when your yellow lights come on during argument, we ask you to wind down your presentation, and the red light means you need to stop speaking unless the court has a question for you. We're also familiar with the briefs and record excerpts. We have not necessarily read the record, and we appreciate record citations when those are applicable. With that, we call the first case of the morning, number 23-10802, Paxton v. Dettelbach. We'll hear first from Mr. McDonald.
I got to get that pause button ready because I know I'm going to be hitting it.
Good morning, may it please the court. My name is Tony McDonald. I'm here on behalf of the individual plaintiffs, and Mr. Eldred will be up to talk to the state's interest in the second half of this presentation. I'm joined by Mr. Martin, Tracy Martin, who's one of the three individual plaintiffs in this case. They've testified that they wish to make a simple noise suppression device in their own homes with their own skill, with their own materials. But unlike the mufflers that are attached to our cars and our lawnmowers, they want to attach this device to their firearms. Mr. Martin would tell you.
And here's something just for that. A couple of guys brought it up in chat earlier, that in most other countries that actually allow you to have a firearm, suppressors are considered polite. Whether you're hunting, whether you're at a range shooting, they think it's completely rude to run out there without a suppressor and start banging away, like with some of the muzzle brakes we use that just, hell, they'll give you a fucking concussion. In America, these politicians, these NPCs, they all have this idea, and God knows they've watched John Wick and they think that's how it works, where you could be firing a gun with a suppressor in the middle of a subway station and no one's going to notice. Tile blowing up, going past people's heads in a crowd. Oh, it's so quiet. That's not the way it fucking works. Physics is a thing, kids. And yeah, and you should, I said it earlier, you should be able to challenge these unconstitutional laws without first having to be convicted and go to prison and spend millions of dollars, because that's what a lot of this costs, to challenge this unconstitutional horseshit. Shouldn't be that hard. We have the text of the Constitution. This is the law. We match those two together. Oh shit, these two don't fit. I should be able to write something up, send it into the court, and be like, hey, this isn't jiving. We need to work on this. Shouldn't be that hard to challenge this shit.
That he believes every home defense weapon should be suppressed. Not only because it protects the shooter's hearing, but it makes them more attuned to the threat, to know when the threat is eliminated. The plaintiffs here seek to make these devices. They wish to make these devices. And it's not disputed. If they were to go home and make these devices without seeking the federal government's permission, without registering the devices, without serializing the devices, and without paying a $200 tax if granted permission to make the devices, it's undisputed that they would face 10 years in prison. Mr. Martin could leave here today and he could proceed with this course of conduct to make these devices without seeking the federal government's permission, and he would face 10 years in prison. That's not disputed. The Supreme Court in Babbitt has told us that a course of conduct, when a plaintiff proposes a course of conduct that is arguably affected with the constitutional interest, that is prescribed by statute, and where there is a
Now, hold on. I got to stop that right there. So, and this is another thing that gets underneath my fucking skin. So, yeah, think about it. 10 years in prison, a decade of your life, or more, depending on how many suppressors you have and what you get charged with. A decade of your life gone merely because you made an object you can screw onto the end of your own gun to make it quieter. You didn't deprive anybody, getting back to the principles, you didn't deprive anybody of life, didn't deprive anybody of liberty, didn't deprive anybody of property. The mere action of making the thing, 10 years in prison. Instant jail. And you know, look at CRS's case, look at freaking Dexter Taylor's case in New York, look at a bunch of others. The mere act of doing the thing the government told you can't do, even though you never harmed another living soul, you get to go to prison. And these fucking NPC juries will convict you for it. There's not a single person on that fucking jury looking around and going, wait a second, did they hurt anybody? No. Did they rob anybody? No. Did they hurt somebody's face? No. Then why are we here? There's not a single person on the jury that does that. We live in a country run by NPCs, kids, non-playable characters. They just get their updates from the government and then they go mouth that shit out to everybody else. And they're too fucking stupid to ask why. Why are we here? Why are we doing this? Why was he even? No, they just.
Reasonable fear. Here there's not just a fear, but a confidence that there would be a prosecution. That those plaintiffs are not required to break the law in order to test the law.
They're not required to break it, but the reality is they've got to do more than just wish. They've got to do more than express some ephemeral.
So again, this is the standing argument. This is the you haven't been harmed. Nothing's happened to you. You don't have standing in the court argument. It's what they're going through here.
Desire to do something that might run afoul of the law.
That,
What do you
What's up,
have
Brother
in your case
Tortown?
besides their declarations?
So I would challenge the premise slightly. I don't disagree with you. What we have is sworn declaration testimony that these plaintiffs wish to proceed in the.
Warsaw, man, if it wasn't such horseshit having to get a suppressor, I'd suppress damn near everything. There'd be very few things I wouldn't suppress. My EDC would probably be the one thing I wouldn't suppress. Everything else I'd suppress the shit out of. What? Just because it's fucking cool. That's the only fucking reason I need is I want to. And if I don't wrongfully deprive someone else of life, liberty, or property, the government shouldn't be in my shit.
Course of conduct that's prescribed by the law.
Well, how far do they have to go? If this were a First Amendment case, and the plaintiffs wanted to parade without a permit, I assume that a declaration only would have to say we're planning to parade and we think a permit is unconstitutional, so we're not going to apply for one. Would that be sufficient?
Well, that would be, and I will say the First Amendment context, there's relaxed standing. That's not clear in the Second Amendment context. But what Babbitt tells us is that
Yeah,
there's
Warsaw.
a general rule which says you propose a course of conduct that's prescribed by law that's subject to a reasonable threat of prosecution. Then the court looks at instances where that proposed course of conduct is imaginary or speculative. And so that's how we take care of cases in which there are contingent things that might happen or might need to happen in order for there to be standing. Here, there's no contingent thing. Mr. Martin could, like I said, could leave here and could travel to his home and begin the process of making a firearm suppressor.
Well, look, you have limited time, and we understand that, but the nub of it to me is, do they have to allege precise facts about, I've already bought a 3D processor, or I already have metalworking equipment, I have the knowledge, I have...
No, they shouldn't have to allege any of that. What they should have to do is show this is what the Constitution says, this is what this law says, and this law doesn't fit within the Constitution. And the argument later we hear is, well, suppressors aren't firearms, so how do they fit into the Second Amendment? Well, if they're not firearms, why the fuck does the ATF get to manage them then? Why? I'm hoping this is going to be a decision for us, possibly 3-2, and that this continues to move up behind the assault weapons ban, mag ban cases, because the Supreme Court's taking up a lot of shit right now. But we'll see. Ghost suppressors, yep. There are plenty of 3D printed files. Unless you have a metal printer printing in Inconel, titanium, whatever, that 3D printed suppressor ain't getting you very far. Well, I'll say this, Tortown. Yeah, you say the NFA is on its last legs. I'll say this. As long as this next election doesn't keep Democrats in control and doesn't put them in control of the House and the Senate, the NFA will be on its last legs. If Democrats keep control of the White House, then they get more control in the Senate and they actually gain control of the House. They will either pack the court or they're going to somehow force some judges off the court and then pack the court with leftist judges that way. And then we are fucked again. FUCKEDAGEIN, fucked again. Yeah, that's what it's going to look like. And it's the very fact that we have to depend on these courts to defend our rights is absolutely fucking insane anyway. But yeah, that's where we're at.
You know, I know where I'm going to buy my supplies for this. Exactly how much would suffice, number one. Number two, if you are challenging the regulatory regime, our court just issued an opinion, a couple of opinions that say that being exposed to a regulatory regime that is arguably unconstitutional is injury.
Dang on Matt, my brother. Yeah, you are dead on the head right there. Too many statists in government. Way too many. Because to me, the way this should work is judges are supposed to be these neutral arbiters, right? They're supposed to look at the law. They're supposed to look at the Constitution and be the balance or judge whether that law fits inside the Constitution. But we see too many of these judges that rule on their feelings versus the actual facts of this is what the Constitution says, this is what the law says. When I say that, I'm talking about state constitutions and the federal Constitution. See, the federal Constitution shouldn't even get involved unless it is a federal matter. Everything else should be handled under the state. The NFA, Too Many Choices says it all the time. The NFA should not apply to your average individual. We're not federal entities. We are private citizens inside of states. The NFA shouldn't even be involved in our lives. Unless I go to DC, set up a fucking mill and start burning out suppressors because DC is a federal, it's a district. The federal government should just be fuck all. Not in my life. And there's too many choices. Too many choices, my brother. What's up? I didn't even see you there. I'm talking shit. Oh, dude, it's way over half the shit they do is unconstitutional. You're more along the lines of probably 80%. It's way over half. And then these assholes, all these leftist fucking retards are happy about Hawaii when they went with it's the Aloha Spirit shit. But they get pretty fucking pissed whenever another state goes, oh, we're a Second Amendment sanctuary, and the federal government kiss my ass. And Hawaii has the same, just about almost verbatim protection of arms that the Second Amendment does, the federal Second Amendment does. And New York, you bunch of assholes, same thing. The New York Second Amendment, their protection for arms is damn near the same as the federal protection for arms. So if there weren't so many statist judges on these fucking panels that weren't so influenced by their goddamn feelings, none of these gun laws would exist. They wouldn't be allowed to exist. But this is the world we live in.
That's right. And I think you're speaking, Cochran and Axon Enterprises went to the Supreme Court. A plaintiff is found to have standing to challenge an administrative regime that they say is unconstitutional. They don't necessarily have to go through that process in order to do so. So I think that is instructive, although obviously a bit different in this context. To your question about a proposed course of conduct, the plaintiffs have alleged that they intend to do this action, which is really quite a simple action, in their own homes with their own materials. There has really been no factual dispute about that. And we actually were working to develop a factual record in the trial court, and the trial court said, we don't think discovery is needed. So to the extent that there was a dispute to say, well, these plaintiffs are not capable of doing this relatively simple thing, that's something that really should have been developed in the factual record. There's nothing.
Yeah, and that's one that I missed that earlier, but the state was basically saying that these people aren't really capable of making these suppressors. Therefore, they couldn't be harmed by us blocking them from making homemade suppressors. I can make an adapter for an oil filter to fit on a gun very easily. I need a piece of round stock, a drill, and a tap, and a die. Yeah, it would be that simple. I could size that shit out very easily. Tap one side to actually screw into the suppressor, put the die on the other, or I got that backwards. Either way, I can make an adapter very easily. And oil filters, we've seen it on a lot of things, make really good sound suppressors, depending on the oil filter. I will say that. But it's not that hard to take a piece of pipe, thread it on one end, tap it, or put a hole in on the other, and then create some sort of baffle system. Because all you're trying to do is just take gases that would normally change very quickly from a high pressure to a low pressure, which creates the blast or the muzzle report, and you're just trying to bleed them off at a different rate, which lowers that report. Unless you're loading your own stuff or you're shooting subsonic rounds, there's not much you can do about a supersonic crack of a round. But as far as limiting the noise at the muzzle, that ain't that fucking hard. if people can make nefarious things easier, yeah.
More that these plaintiffs could do other than say in sworn testimony, in a sworn declaration, sending that to the Attorney General's office, hiring an attorney and bringing a lawsuit to say, I intend to engage in this course of.
Oh no, Lightning, are you talking about pressure cookers that were used to kill people during a certain marathon? And yeah, I've got a couple of them. Yeah, I've never had to register my pressure cookers. Never. All it would take is some very simple modifications, and that thing makes a hell of a goddamn bomb. But then again, so do water heaters. If you have a water heater in your house, you have the potential for a huge explosion just from steam.
Conduct.
Well, right now, you are also challenging the regs that say we want photos of every single component, right? And not just the tax, but we want, basically all your background information. So you can file an application that we may or may not grant, and if we don't grant it, we may, because you've sent us incriminating information, we may prosecute you, right?
Well, and that is a factor. So
Yes. Again, getting back to fluid traps, which typically had a solid cap on one end. They had either freeze plugs or cones in there that weren't drilled, and a threaded end on the other end. So basically what you could do is get this thing, drill all the parts out as long as you were concentric with everything, do a Form 1, make your suppressor, send all the stuff in. You had a suppressor at a very cheap price. You can make the son of a bitch at less than $50. Easy. Easy. Would it be the best suppressor? No, probably not. Would it work for most people? Yeah, probably. Then the ATF said, nope, we're doing this rule change. And, oh, nope, these fluid traps. Nope. You have to send us pictures of everything you're doing. You have to send us basically a drawing, how you're going to do it, the parts you're going to use, what the parts. And if you have any of these cone cups, if you have this threaded tube, Maglite, you are already in possession of suppressor parts. Therefore, that's illegal. And we either are going to come get those things from you, or we are going to put you in prison. The only way you make this make sense is if you're an absolute non-playable character. That's the only way this makes any sense. Other than that, common sense is fucking dead. He got crucified 30 years ago, and it's still hanging on the goddamn cross, rotting to death. Red Dawn Readiness, my brother. What's up? And yeah, dude, this shit is absolutely insane.
Well, is that part of the basis for your claim of standing?
I don't think it's necessary, but it is helpful. The unique circumstances here show additional reasons why they're standing. So to add to that, there's an application process, but what we have alleged in this lawsuit is that application process is being used to abusive ends. Some applicants are being made to wait indefinite periods of time that the ATF has been asked.
Well, we can't, how could we adjudicate that unless you had actually applied?
I disagree. I think the question is this process applied to this exercise of this right?
What do you do with the case law that says silencers are not protected under the Second Amendment because they're not firearms?
Well, I think it's premature for this court to reach that question, but I think it's wrong.
There's case law to that effect, correct?
Again, one of my arguments, if it's alcohol, tobacco, and firearms and explosives, a suppressor doesn't do any of those things unless you get a real bad baffle strike. Caveat. But either way, and especially you guys that have been around long enough that have seen us go through the House hearings for the 1934 NFA, if it's not a firearm, the ATF needs to get fucked. They have no right to regulate it. It's not a firearm. You can make the argument that, okay, a grenade launcher is a firearm. It uses the explosive energy of a propellant to launch a projectile. You can make plenty of arguments for stuff. But a suppressor is basically a can with baffles with 2 holes in it. You can't get it to shoot a fucking bullet by itself. To actually fire off a projectile and send it down range by itself, it's not a firearm. It would be the same as the ATF saying, I don't know, this fucking flashlight's a grip. Which they will do that. Not put it past them. They'll do that in a fucking hurry. But either way, it's just so much absolute horseshit. So this is the government pissing down your neck, telling you, hey, we're pissing. They're not even telling you it's raining at this point. They're telling you, I'm pissing down your neck, and there's jack shit you can do about it. They used to piss down your neck and tell you, hey, it's raining. No, now they're just, oh, my sense of humor. That could have gone so many places. Yeah, now they're just pissing right over your forehead and showing you the dick and everything and being like, no, nothing you can do about it. Ours is bigger than yours.
District court cases, non-binding cases, but the U.S. Supreme Court has told us in Heller, in Bruin, they describe arms as articles, modern instruments that facilitate self-defense. It's a very broad definition for what an arm
Well, we're
would
going
be.
to find out what they say about Bruin, I guess, shortly in Rahimi, but still, you've got where's the case law that says a silencer is protected under the Second Amendment?
There is no case that says a suppressor silencer is an arm. That's a question that I think ultimately may get to this court. I don't think it's primed for you to rule on that today. I think that's to the merits of this case as opposed to whether we have standing. But these are the answers that this case is meant to provide, and these are the questions that we're trying to ask the trial court to answer.
Okay, you have it, Will. Thank you. Mr. Eldred?
Thank you, Justice Jones. May it please the court, I'm Charles Eldred for the state of Texas. As applied to citizens making firearm suppressors for non-commercial personal use in Texas, the challenge statute and rules affect Texas's quasi-sovereign interests, and therefore Texas has standing also to pursue this case. According to the Alfred L. Snap opinion, quasi-sovereign interests consists of interests the state has in the well-being of its populace. They also say it's a quasi-sovereign interest in the health and well-being, both physical and economic, of its residents in general. And importantly, this is an interest apart from the interest of the particular private parties. So this is not a parents patriae case. The Mellon bar does not apply. Mellon v. Massachusetts, as recognized in Massachusetts v. EPA, specifically said that this is not a case about quasi-sovereign interests. Quasi-sovereign interests are the kind of things that states can bring on their own behalf, again, to vindicate the health and being, both physical and economic, of its citizens, residents.
Sorry, did hit both buttons. Here's something here. The federal government is not the sovereign. We, the people of the United States, individuals, are sovereign. The states could be considered as sovereign. The federal government fucking can't. The mere fact that the federal government is considered injured in a lot of these cases is fucking mind-blowing to me. all the federal government does is injure people. I've got my same arguments with state governments in a lot of cases. But we're talking about something sovereign. I have the right to make up my own destiny, make my own choices. Again, unless I violate very simple principles. As long as I don't wrongfully deprive someone else of life, someone else of liberty, or someone else of property, the government as a whole, state or federal, can eat a bag of dicks. They can eat them with a fox. They can eat them on wearing socks. They can eat them on a plane. They can eat them on a train. They can eat all of them. Big ones, black ones, white ones, red ones, short ones, white ones. Notice I mentioned white after short. But yeah, they can eat every single fucking one of them. It is none of their goddamn business. If I had 47 machine guns and 97 suppressors behind me and I never heard another living single soul, innocent soul, say that with them, it should be none of the government's business. Again, you guys are catching me after a little bit of a rough morning, so here we are.
In general.
Let me ask you, does section 2.052A of the Texas Code, does it do anything beyond exempt the suppressors made in Texas from federal law?
I don't have it in front of me, but
Hold on. I got to hit this real fast. Oh, well, actually, I might have to take a call real fast. Let me let this play.
I don't think the law does. What the statute is
It's
intended
Cooper.
to do is not to let, say, a citizen's make the suppressor and then go to federal court and say, ha, I've got this law that says I don't have to do it. It does not exempt citizens from the operation of federal law. It sets up a sovereign interest in Texas is a sovereign interest in having citizens make these things. And this is what the law does. And it tells us the Attorney General to come to court and try to vindicate that sovereign interest.
What is the sovereign interest?
Sovereign interest is Texas's.
Okay, I got to say this real fast. Mammy, if you are lurking in the chat, which you do a lot of times, I just got another call about you and Dad selling the other property over there. I'm up to 340K. That you just hung up on me. So there we are. It's just fucking, oh, dude, man. I get so many calls these days to sell the other 5.5 acres or 5.33 acres that I have. And I get calls where they think they're talking to my dad, where they've got another house that they own. I get calls a few times a week on both of those properties. Now, I have nothing to do with the house that my parents own. Nothing. All I do is just try to jack the price up. I started at 180K. I'm up to 340K right here. Because I'm pretty sure, if they want to buy it for 340K, the folks might do it. But Jesus Christ, man. That's a whole other strain. I'll get into that sometime later.
Interest in having its citizens be able to make suppressors for non-commercial personal use for self.
How is that a state sovereign interest?
It's sovereign interest because the code says so, because Chapter 2 of the Civil.
So you're proceeding under the theory that Texas can enforce.
Hold on. I got to throw too many choices thing up there. State can't exempt, but it's to say that we aren't engaged in commerce, so they have no power. Yes. I talk about it all the time. Your federal gun control is based on the interstate commerce clause, meaning a product traveling from one state to another. That's where the government found their taxing power for the NFA, which is a tax law that has criminal penalties. Fit that into your head. So if I build something in my state, it doesn't leave my state, I don't sell it to anybody in another state, then the federal government should have no fucking say-so in what I do in the first place. Even if I travel into another state with that object, if I'm not selling it to anybody, it hasn't been engaged in commerce across state lines, so it shouldn't matter. So, oh man, I remember distinctly not realizing how these gun laws were actually structured. And it wasn't too long ago, kids. 47 years old? Yeah, 47 now. I remember not too long back not realizing how these gun laws were structured. And then probably the last 5 years, I've actually taken the time, and a lot of time, to educate myself on these things and actually look at these cases. And pretty much every single gun law is horseshit, state or federal, because no state constitution gives the state the absolute power to regulate firearms. Some can regulate the manner in which the firearm is carried, because they will say something to the effect of, this does not, yada, yada, conceal carry of firearms. Okay, I can dig it. As long as you let me carry my firearm open, we can probably get along. There is no law, no part of the Constitution that gives the federal government the right to regulate arms inside of the states. Not a single fucking one. And I'm sorry if you guys don't like my mouth. Get over it. This is me. I'm short, fat, and got a foul mouth. What can I say? Chessboard, my brother. What's up? And for those of you who don't know, Chessboard's another good brother, but I run his monthly prescription for blood pressure meds up so high he can't hang out too long at one time. What kind of it's funny since most of my audience is guys like me. Yes, Gabriel, there should be. New Hampshire or Minnesota. I went to New Hampshire, but Minnesota is supposed to have some gun laws coming up today. Matter of fact, I've still got their stream up. Let me make it live and let's see where they're at. Oh, that one went out. That was the Senate. So I'll have to look. I had the Senate up. So, brother, I'll have to look because there were supposed to be a few bills come up there that about gun control. Hold on. I'll show you guys another tab real fast. Where's it at? I know I bookmarked it. If I quit clicking on the wrong shit, I would be absolutely dangerous. Bookmarks. And then we'll get back to the oral arguments. Screen share tab. So yes, this is what we're expecting to come up in Minnesota today. Let me show more right there. Trigger ban and straw purchase don't even belong together. And then the mandatory safe storage session being for meetings. I'll have to pick through that because it said they started theirs at 11 and I was busy as hell this morning and then got home and started doing this. So, yeah, I'll have to go back in and actually look for some of that. But yeah, there's stuff in Minnesota. I know there's still stuff in Colorado. There's still stuff going on in Michigan. And if any of you guys know of anything, send it to me, man, and we'll cover it as well as I can. I got a job, a wife, 2 kids. I might be a little behind on some things, guys. I'm just saying there's some other stuff eating up my time, even though my wife wants to drown me for all the stuff that I do now. And I do hunt and fish and try to do other things. Oh yeah, dude, the current interpretation of the Commerce Clause started out in basically, I think, the 20s. And I've talked about one of the first cases having to do with the Interstate Commerce Clause before, where a guy grew more than his allotted amount of wheat or grain in a year, and the government went after it and basically said, since you grew your own wheat or grain, whatever it was, and then you not only did what you wanted to with it, but you also fed your animals with it, you deprived others of commerce in other states, so therefore we can regulate that. And I'll have to go back and look at that case again. That's me remembering offhand. But yeah, the Commerce Clause has been absolutely bastardized, much like many other sections of the Constitution at this point. Yeah, and Too Many Choices has it right there. It's absolutely freaking disgusting what the government does. And what a lot of people don't realize is, like, when the 1934 NFA went through, we had a president that was threatening to pack the court because they wouldn't approve a lot of his progressive agenda. And they kept telling him, this isn't constitutional. That isn't constitutional. No, you can't do that. It's not within your powers. He was like, look, I'm going to pack you guys with even more judges that I pick so that they will rule in my favor. And that's basically how we end up with a lot of the shit we have now. If you don't think we are in that same time right now, yeah. The Democrats been talking about packing the Supreme Court again for a long time. And if Democrats stay in power this year, if they can't get rid of at least 2 conservative judges on the Supreme Court, if they can't get rid of them for some bullshit, you can bet your ass within the next 3 years that court gets packed. And then it'll be packed with leftist judges, and then we're going to fight the next 20 years to get that court back into some sort of a balance. And it never should be a balance. The only balance on that court should be, this is what the Constitution says, this is what the law says, does it fit? And if it doesn't fit, much like OJ, you must acquit. Fuck off. No, your law's not constitutional. That's the way it should work. But yeah. Love you guys.
I wouldn't put it that way.
Are you not proceeding under that theory?
Am I proceeding under the theory that Texas? Well, the code doesn't do anything other than order the Attorney General to file a lawsuit.
Well, that's sort of what I'm getting at. Back to Judge Clement's question. I mean, I'm struggling to find what sovereign interest Texas has that's distinct from the individual plaintiff's alleged interest in rights.
Well, 2 answers. The quasi-sovereign interest is defined as...
Quasi-sovereign is different than sovereign. I'm trying to get at what the sovereign interest of the state is.
That's the sovereign interest to create and enforce a legal code, yes.
Hold on, I'm posting that, Bob.
Basically said that the legal code here just says this
if I could, I would.
Federal law. And the Attorney General needs to bring this action.
It does say that, that's true. It is a clash. It does set up a clash of sovereigns, though. We say, the statute says, our legislature says, that they don't think the federal law is constitutional, and they want this Attorney General to do something about it.
Yeah, but the state can't set up a clash of sovereigns by passing a law that says we disagree with federal law.
No. Hold on, asshole, judge. Even though you're a federal judge, you should still understand the Constitution. And the federal Constitution only applies in federal matters. The state constitutions apply in state matters. If those two disagree, as long as the right gives more power to the people in the state, then the Fed shouldn't be able to do anything about it. Now, if the right in the state is so restricted that it is underneath the federal constitutional authority, then the feds should be able to come in and say, no, you can't do that because this is the right. Giving people more rights is different than taking away their basic rights. That's the way that should exist. And too many choices, you motherfucker, man. We got to do a show one day together, asshole. You ain't got to come on the stream. You can throw your avatar up, but we got to shoot the shit, man. What's my brother Gabriel saying? No, there's one Gabriel in 1924. I swear. I've done a show on it before, so it was before 42, well before 42, where the government came in and said, if you're doing this and you're not competing in interstate commerce, we still get to regulate it. I'll look that case up again. I've got a video on it very early on my channel. It was probably in the first couple of weeks that I had my channel that I did that video. That is another case that was built on that one, but the original one wasn't the Filbert. Link too long to post here. Hey, much like titty pics, just post them in your bio, Bob. Pics in bio. That's almost one of the reasons I quit screwing around on Instagram so much, because I had so many hoes of the gram driving me crazy. Hey, new file, whatever. You click on it. Not that I mind seeing titties. Don't get me wrong. I like titties. I am a titty fan. But when I'm doing something that's actually related to our rights, that's kind of what I want to focus on. If you run me down the rabbit hole of nice titties, I'm going to be there for a little while and I won't get to do what I want to do. Just saying, it's a fact. Trust the science.
There are cases out there that say that the state can't pass a law, can't create a sovereign interest just by saying, "Hey, citizens, you don't have to comply with federal law." I agree with that. I just don't think that's what Chapter 2.
Zany, what's up, my brother?
What does it do?
It tells us it sets up this very lawsuit, which is a different thing than just saying citizens don't have to
Only
comply
on
with the law.
Instagram, brother.
Chapter 2 does
Hold
not
on.
say citizens don't have to comply with the law.
I got to address this in real time. Only on Instagram. In real life, not so much. Just saying. I ain't got it like that. If I was 6'4" or something like that, no, my ass is like Hobbit 5'8" on a good day.
We can set up a lawsuit to allow the state to come in and say citizens don't have to comply with federal law.
That's what Chapter 2 does, yes,
I
sir.
think we're completing the circle. What about quasi-sovereign interest? How are the state's quasi-sovereign interest here distinct from what the citizens would bring as individual claims?
They're distinct mainly because the Supreme Court has defined them as distinct.
But no, I think the state has to articulate some distinct quasi-sovereign interest in order to proceed as a plaintiff, does it not?
Well, I think we have. It's the interest in the health and safety of our citizens.
But how is, I mean, you can't just generally say that
Check
and proceed
my
to
brother.
intervene as a plaintiff or stand up as a plaintiff in the lawsuit. How are the quasi-sovereign interests of the state of Texas affected, distinct from what the individual claims are?
Okay, DM gives me a reason to use a Joe Biden quote right here, which I do this completely being a smartass. Don't jump. If you've never seen a Joe Biden speech where he talks about someone in the balcony and says, don't jump, you got to watch it. He does it in a bunch of damn speeches. But anyway, Jason, what's up, my brother? Of course, Zany came in. DM's been here for a little while. Zany talking shit. No, I love you guys. But yeah, let's I need the Walmart brand of Tylenol to sponsor my streams, because that Motrin, methamphetamine, something to kill the goddamn pain.
Well, it just, I don't know how else to say it. It's just defined as the state's interest. The interests are similar, they overlap a lot. The citizen has an interest in his own health and safety, but also the state has a separate interest in the citizen's health and safety, according to the law.
Yes, but that doesn't give the state the ability to intervene in every case where a plaintiff's health and safety are implicated, does it?
Every case? I don't think so, no.
What's your best case to support standing here?
Probably Massachusetts v. EPA, which they said was a quasi-sovereign interest case.
Hey, you leave the keystone out of this, Bob. Don't be picking on my keystones. I can't drink cheap liquor. I can drink cheap beer. What can I say? Leave my keystones out of this. If man against the masses, if you are in here lurking, don't you throw another Bud Light can in my hand. It was Keystone. Keystone. As I give him all the ammunition he needs. Yeah, you're right, Lightning, dude. It is seriously painful.
That's the case, of course, that kind of set us up down this path of all these lawsuits being brought. I do want to say one thing about...
What do you do about Missouri v. Biden? Didn't that cut back on Mass v. EPA? Isn't that the one? Well, I get them all confused now, but it was the one about immigrants, about the requirement of the alleged requirement of the federal government that it shall remove criminal aliens.
We call that the prioritization case. In that case, they found we had no standing because there is no
I
standing
wouldn't admit that, Bob.
to order the federal government to arrest people. The federal government has authority or...
Hold on. I got to throw the wife's comment up here. What you doing? That's exactly how I should say it. The same thing I've been doing for the last hour and almost 40 minutes. Listening to oral arguments and bitching about them. Same thing. So if you guys see Rebecca Tamison in the chat, that is my wife. Yes. She hasn't killed me yet. I don't know why. I still ain't figured that out yet. Excedrin buffer. Yes. Where are all these people that want to sponsor something? Because I need them to sponsor my streams.
discretion to arrest people or not.
So that wasn't a direct challenge to Mass v. EPA?
No, I don't think it was a direct challenge to that. If I can squeeze in a little bit about the Anti-Injunction Act, I will acknowledge that our reply brief is incorrect when we say it's...
I don't have enough life insurance for you to kill my ass. Unless you got some policies I don't know about, which is likely. Love you. And you are completely sexy as hell. Back to our regularly scheduled program.
But it's not supported by the record. I see my time is up.
Okay, you have a chance for rebuttal. Mr. John Doe?
Yeah, you laugh, but in all seriousness, you are hot as fuck.
Thank you, Your Honor, and may it please the court. Sean Janda for the federal government. The district court correctly held that no plaintiff has established standing to challenge the NFA's restrictions on making silencers and dismissed plaintiff's complaint without prejudice. This court should affirm.
Suppose, what would it take for plaintiffs?
Oh, God, I hit the freaking wrong part of the button. Hold on.
To turn to the declarations, I think the
government couldn't target other specific...
We denied that there's a problem with the delay because
that allegations...
File an application if they...
You've been injured and we have standing.
Switch you come to my stream. So what the state is arguing here is that the plaintiffs in this case haven't been harmed yet In other words, they haven't gone to prison for 10 years yet. They haven't had their door kicked in. They haven't been shot in the face. So they don't have standing in this case. They can't challenge it. That's what the fucking federal government's arguing right now. Running. Vanessa Kitty, what's up, my sis? Hey, no, Bob, I don't know. I haven't checked on the insurance stuff in a while, and she probably has a couple of policies on my ass right now. There's a skateboard in the, well, no, it's on the porch now. There is a skateboard on the porch.
And then, if the court has no other questions about the individual plaintiffs, I think just turning really briefly to Texas's independent asserted claim to standing, I think the fundamental principle that we divine from the Supreme Court's cases is that a state cannot bring a lawsuit against the federal government if the state is really asserting the interests of its citizens. And here, I think Texas is just saying they would like to assert their interests.
What was the interest asserted in Massachusetts?
This dude breathes really heavy and talks really fucking fast. And some guy said in the chat earlier, don't ever trust anybody that talks that fast. Because he's talking that fast, but he ain't saying a goddamn thing.
Versus EPA.
So there were two interests, Your Honor. I mean, one, the substantive interest was that, Massachusetts' view, part of the state.
Water was going to rise.
Right. I mean, part of the state was going to be submerged. I mean, that's a.
Oh, this judge busts his balls right here.
Which of course, 30 years after the fact is demonstrably untrue, but that was good enough for a hypothesis, right?
I mean, I think the interest there, or the claimed injury there, and whether or not that injury was borne out or not, I don't know. But the claimed injury was that part of the state was going to be submerged. I mean, I think that's a pretty core territorial.
Well, tell the Obamas that.
And then I think the other thing, Your Honor, is that there was also a procedural component to the interest there, which was that Massachusetts had filed a rulemaking petition in that capacity to vindicate that substantive interest. And that.
Yeah, DM. Well, it's already went through a couple of huge court cases. I have to go look them up, where it was basically said that law enforcement officers or the government could lie to the average person's face, absolutely lie to them, and not be held accountable for their lies. I believe one case went all the way up to the president of the United States, and that was, of course, a federal case. And it came down to, yes, the president can lie to the American people and not be held accountable. There's some small stuff that's come down different than that, where courts have said, no, they can't just lie about shit. But most cases come down that, yes, the state and the federal government can lie all day long and not be held accountable. PLA, what's up, my brother? PLA, you know we all about the oral here, man. All about the oral.
Rulemaking petition had been denied. And so here, there's just none of that. And I think that the footnote that they rely on in Massachusetts says very clearly, it may be the only very clear thing in that footnote.
Hold on. No, since Matt said this, I got to pause it again. Throw this up here. No, the people can't lie. You can't even misremember something in a hearing without getting charged with perjury. Ask General Flynn. If you haven't looked at that case, that's a whole nother rat hole. But no. You can't do it. But the state or the federal government can do it. This is rules for thee, but not for me territory.
Is the state cannot sue to assert its citizens' interest in avoiding the operation of federal law. And that's just exactly what Texas is doing here. They think their citizens...
Vanessa, I don't know what size policy hat she has on me. I'm definitely afraid of her killing me. Just saying.
In this context, shouldn't have to comply with the NFA. And again, whether they're right or wrong about that, that's a claim for their citizens to bring, and not a claim that they get to bring on behalf of their citizens. And then just, I think the final piece of it is, I don't think enacting a state statute that sort of codifies the litigating position that
Well, what about all the cities that pass laws, or states even, proclaiming themselves sanctuaries?
Yes,
I mean, I think
Vanessa.
you can pass whatever law you want. I mean, we don't have any problem with Texas choosing to codify its litigating position.
Lion Rich, what's
I'm
up,
not
my
sure
brother?
Well, they all litigated against the government.
my
Some of them did during the last administration.
my memory, Your Honor, and I'm not 100% sure about this, so with that caveat, my memory is that in that litigation, there were grants that the federal government tied to cooperation with federal immigration enforcement.
This this is definitely a juicy one, Vanessa. Be careful on the road, sis. I love you. Be careful. And if any of you guys want this without all the pauses and everything in it, go back to the start of the stream because we listened to the entire oral arguments without me stopping anything and just let them play through. And Rich, if you didn't hear me say hi to you, brother, I said hi to you, brother. Love you much. And let's let this keep on kicking.
And that was really the underlying interest. And so it wasn't just sort of the bare interest in proclaiming a disagreement with federal law, which I think is all we have here. I mean, the NFA, in relevant part, doesn't require Texas to do anything. It doesn't regulate Texas. And so, Texas can pass the statute, but I don't think they can leverage the statute to create standing where none would have existed otherwise. So if there are no other questions, we would ask that the court affirm. Thank you.
All right, so that was the federal government's argument. Now we get to the rebuttal. So just keep everybody on track. I know we've been bouncing around for this last little bit during these. So the plaintiffs from Texas went first. They stated their case. The federal government got to state their case, and now the state guys get to come back and state their case again for the rebuttal. And this doesn't take long. And I'm going to jump off here after that because it's been a long day already. So this is the rebuttal to the federal government's end of this case. If I hit play, I'll hit it one of these days.
Thank you. Just a few things. I believe the ACF's position is that they can use the information that is provided to deny the application. So if you send them
Georgetown,
pictures of
yeah,
your
you ain't
parts
wrong.
of a suppressor, they can say, hey, you're already violating the law because you already own a suppressor, because the parts of the suppressor are defined as a suppressor under the law. So if you send a picture of the parts,
But if plaintiffs have that fear and they make the application and they don't send a picture of the parts, they've applied for a silencer. They could even state on the application, we're not sending pictures because.
If they apply for this, if they apply to build a suppressor and they don't send in a list and pictures and diagram of everything they're going to use to build the suppressor, then the federal government says you can't have that permit because you didn't show what you were going to use. You're denied. If you show everything you're going to use and the federal government says, wait a second, that freeze plug is considered a suppressor part already, we're denying you anyway, and we are going to come get that suppressor part, and if you decide to not give that up, we're arresting you. That's how this shit fucking works. I want to go there, but I don't want to go there. That may be a Rumble stream one night.
We don't want to run afoul of the law. And then when the government denies the application, have they not then suffered an injury?
I agree with that.
Counsel opposite just said they would.
Well,
There wouldn't even be a dispute about standing if they just filed that application I just described.
I agree. I think we agree with that one. But we do think that the application itself is the injury. I mean, imagine if you had to apply to discuss the election in your own home. This is different than the parade example. This is a.
But you just, I mean, I think you just gave away the game, did you not? The application is the injury. The application is not legal or illegal, and filling out an application is not legal or illegal. It doesn't subject you to any criminal.
Dude, too many choices we all have. At this point, we have all suffered an injury from the NFA existing. Just the existence of the NFA is an injury. So, dude, you're 100% fucking on it.
Penalties, but it does subject you to an injury because you've got to have filled it out. But they haven't done that here. No injury, no standing.
Well, we're
Oh. All right. And this is a rebuttal. We're going to be off here soon. But this is one of my biggest arguments with a lot of shit about standing. The judge is asking him or telling him, you haven't applied for the tax stamp. You haven't went through the process. Therefore, you haven't been injured by the process because you haven't been denied or you haven't been jailed due to the process. But here's the deal. You fucking dumbass judge. You are supposed to take the Constitution. You're supposed to take the law. Look at it in the frame of the Constitution and go, this is constitutional or this is not constitutional. That is your fucking job. You are supposed to be either a neutral arbiter of the truth, or, in my opinion, you are supposed to side more on the side of the people than the government because you are supposed to be that so-called check and balance. You fuck nuts. Like I said, it's been a morning, so you guys are catching me a little spicy. Night Strike, what's up, my brother?
saying that this is the case where you can sue before there's an injury.
I understand pre-enforcement, but still, you have to have some threat of injury or something that's substantiated before you can just come in and say, well, we'd like to do this, and so therefore we're going to sue.
Our count one is we want to be able to make firearm suppressors in our own home for non-commercial personal use without doing the application, and that's the difference, I think. It's similar to what I was about to say about needing to apply for permission to speak about the election in your own house to your own family members. This is
100%, Bob.
If that was a law that said you had to do that, it would be easy to say there was standing. But you don't have to apply for permission to speak. Second Amendment law, of course, is developed because Bruin's pretty new, but we think the same issue. If you have to apply to make a suppressor in your own home, again for non-commercial personal use, not even to take out of the state, they have to stay in the state. We think this is what the statute says. Is very similar, I think, to applying for permission to speak in your own home because there's no time, manner, or place restriction. There's no imaginable reason why the government can do that if you have a right to bear arms.
Okay, First Amendment. If we go with this typically, or just off First Amendment grounds, okay? I wake up in the morning. And yeah, I do wake up in the morning, kids. That's why I'm so fucking grumpy these days. I don't have to wake up in the morning and submit a permission slip to be able to talk in the morning. Why? Because I'm not wrongfully depriving someone else of life, liberty, or property. I can talk to my kid in the morning. I can't talk to my wife in the morning. She will admit she will knife me in the fucking neck if I talk to her at the wrong time in the morning, if she's being honest. I pretty much got to poke her with a stick to see what mood she's in. No, you dirty bastards. I'm talking about like a stick. But yeah, I don't have to wake up every morning and get a permit to be able to speak in my own home. I'm not affecting anybody else. Why should I have to get a permit to do any other thing that is supposed to be constitutionally protected? It makes no logical sense. It makes no logical sense to say you don't have the right to speak because this other dude is racist and did a call for violence against another group of people. That's him. That's not me. You don't have the right to own this because this dude used this gun to kill people in Vegas. I don't give a fuck at all. One, that's shady as shit because we've never heard everything about that whole situation. Never. And I have plenty of people that I know that have fired the weapons in combat and said, "No, dude, that wasn't a bump stock." I know plenty of those people. But even if it is a seriously heinous situation, dude drives his Ford whatever SUV through a crowd in Wisconsin and kills 7-8 people. You don't ban SUVs. Guy in Nice, France, 87 people in less than 30 seconds. He drives his truck through a crowd, kills that many people. You don't ban trucks. Can we get down to the actual reasons for a lot of this? Can we start to address those? No, someone did it, you lose your rights. How much sense does it make for someone who has never heard a single other living individual without just cause to lose their rights because some dickhead went out, used the same product, tennis shoes, pants, he had something to eat that day, to harm someone else, and you take everybody else's rights away? It makes no fucking sense. It's where I tell you guys this is all about control. This is not about safety. This is not about saving lives, because if they did that, they'd look at both ends of the scale. About 7K murders with guns a year versus a million at least defensive gun uses a year. That scale is way off kilter. This is about control. Suppressors, same fucking thing.
What's the, well, and that's, what is the statutory and constitutional basis for the challenge
hold
to
on.
the regulation?
I got to pause it again
Assume
real fast because
standing,
Lightning's
is
got a
your
good
claim?
point. Well, Lightning at this point, they're going after the precursor parts for guns, which is either a receiver or an unfinished frame or anything like that. So technically, it is legal to build a firearm for yourself these days. But yes, it is still illegal to build a firearms accessory by yourself. And for anybody with a logical brain to make that fit, oh, dude, I will do a live stream with you in a hurry. Let me know. CNT Designs on YouTube, Instagram, fucking Twitter, you name it. Hit me up. If you want to justify this shit, hit me up. We will do a stream at the drop of a fucking hat. If you want to justify this stuff and how it actually saves lives. Yeah. Hit me up. We'll do it. I will debate you. I will do my absolute best not to be a complete smartass. I'm not saying it's not going to happen. I will do my absolute best to not be a smartass. If you say something too retarded, though, I will tell you this. I will tell you you're a fucking retard.
What is the plaintiff's claim? Does the regulation violate the APA?
Hold on, Knight.
Does it violate the Constitution? What's alleged?
The Constitution, and also the rules violate the APA.
The APA. And these are procedural rules.
I had my email.
Because they're licensing rules. So it's a procedural regime.
To that extent, yes, they are procedural rules, and that's been defined as a quasi-sovereign interest as well. Texas has interest in
Of course, my connection goes
challenging
fucking
procedural
crazy.
rules.
Well, and the plaintiffs have, again, we do have cases that say the being subjected to an illegal regulatory procedural regime is injury sufficient for standing.
Yes, and we're saying that too. And
What's your best case for that?
Exxon, I think.
I'm working on it, Knight.
Oh, AXON?
Yes, if I'm
Okay.
pronouncing it correct.
All right.
Just one more thing on the sovereign interest. The statute, we would say,
Headed to you.
a better answer to what I should have said before. It promotes firearm suppression. It promotes the building of firearm suppression, so making of firearm suppressors by citizens
Yeah.
for their own
That's
use.
right. Headed to
That's
you,
the
brother.
sovereign interest that it implements. And I think there's no other questions. I'm done.
Okay, I think we have your argument.
I would like to watch Fallout tonight because I'm going to get off here. Hold on.
Cases
So
this
that was-
morning,
that
but
was
we
basically
also
the
have a
casing.
timetable. So when your yellow lights come on during argument, we ask
here.
you to wind down.
Remove that from chat and let me answer a question here real fast.
Oh boy.
Oh, it's from the wife. I still got to add you to the. Hold on. Which button do I hit? This is the
There
one I
we
hit. Okay. So yes.
Let me know what you think from someone's perspective who isn't a gamer. Because, you know, from what I
So
hear,
yes, because
all the Fallout fans love the series. Okay, I love it too. I'm a Fallout guy. I play the games. But if you haven't played the games,
yeah, I did
you
too.
might not understand the series.
No, I started out with Fallout on Xbox. I didn't play it on PC, but I played it on the Xbox. I love the fucking game. That's what has made me so terrified about watching the series.
Well, if you haven't at least played New Vegas, it's gonna be a little weird.
Well, I found New Vegas to be gay as fuck.
It was boring starting out, but you know, nothing is better than, you know, in New Vegas, you know, you having the ability to walk into that dude's casino and shoot him in the head and see how he feels.
Yeah, because I started playing Fallout. Fallout 3 came out on Xbox.
I've played them all.
I got that, and I played through Fallout 3. God, a couple times.
I preferred when they started the Fallout games being first person instead of third.
Yes.
Yeah.
Anyways,
answer your wife.
Oh, hold on. Dropping shit. Where'd you go?
Coop's house is on fire.
Fucking be all right if it catches on fire. But yeah, baby, I'm probably gonna end this in a minute, catch me a nap, and then yeah, when you get home, we will start watching the series.
But
It's between my nuts.
but Coop, I have suffered damages by the NFA.
All of us have.
You know, here's my reasoning. You know my catchphrase.
Shall not be infringed.
I have been infringed because the NFA exists. Therefore,
Yes.
I have suffered emotional and physical damage.
Well, look, a lot of us have built guns. A lot of us, and it is in a lot of cases way easier to build a full automatic gun than it is to build one that is semi-automatic.
To neuter
Semi-automatic,
one, yes.
yeah. To neuter one, you have to add in parts and do stupid shit.
And make the
All
turn so other
the
people
difference.
can't automatically easily make it full auto.
Yeah,
Which
all of us have been infringed.
which the funny thing is with an AR-15, you know, if the disconnector breaks, hey, it's full auto.
Yes, I mentioned
How
that on
stupid is
stream.
that?
I mentioned that on
Is
stream
it
earlier
safe?
today. It was
Oh
like,
hell no! It ain't safe to fire. But
Yeah.
the point is, it negates all that effort they put in to making it.
hey, look at, and I'll fall back to this case all the time. Look at CRS's case.
Yeah, I
Okay,
know.
CRS's case. They tried to do the auto key card thing. They tried cutting it out and do all this stupid shit. And they finally had to use soft primers. They had to cause a hammer follow. They could have done the same thing if they just removed a pin, pulled the disconnector out, put the pin back in, and then fired the gun.
Mm-hmm.
Okay. What?
I know. It's just. Well, the problem is, I think also they targeted CRS because he was advertising for the guy, and that's what they were going after him for doing advertising. So the
A
government
lot of
is
it was.
a government is saying you can't advertise for companies the government doesn't approve of, and that's also kind of illegal.
I've heard people say, well, CRS, well, he was poking the bear. Okay, here's the deal with that.
Okay, anytime you send a letter to the ATF, you're fucking poking the bear. Big deal.
Yes. So CRS did get in contact with the ATF, and he asked whether this was legal or not. And the ATF said this is legal. Somehow they lose the evidence, lose it. In other words, they just fucking delete it. But we live in a country where there is supposed to be right and wrong. And there's supposed to be a hard line in between those two.
No, there's
that line's blurry.
There's just that we live in a country where there's just a lot of wrong, and the right kind of gets through the cracks sometimes.
Yeah, you ain't wrong about that at all. Not to kill that phrase or anything, but
I'm sorry to pin ruin your phrase, but shit has gone literally upside down. It's absolutely freaking ridiculous.
It is absolutely upside down. 100%.
But as I said, I don't have to go, I can file a claim saying that I have been damaged by the NFA because it is clearly infringed on my constitutional rights to keep and bear arms. I cannot use a full auto gun without permission from the Crown.
Yes.
I cannot make one without permission. Or even an FFL for that matter. So technically, whatever law that instituted the the 4473 is also unconstitutional, and I've suffered damages.
Yes.
So
100%. All day long, every day, 5 days a week. Yes.
Mostly emotional damages, but hey, that's damages.
Hey, emotional damage is used in a lot of cases that award people millions of dollars.
And I don't know why the guy who's trying to the lawyer for it, why he's not using that avenue, because that's the avenue they use on us for every other infringement.
Oh, say it ain't so. Do you think the actual anti-gun people would use emotional arguments?
Coop, don't get smart ass with me.
I'm gonna.
I will slap you across the face with a bayonet.
Hold on. Who can put a bayonet on camera sooner? After
I'm not doing it right now. I don't have anything next to me.
Bayonet.
Yes, I'll slap you across the face with that one. I've got that one. No, I've got that one. It's in the safe.
So just admit you lost.
I'm not running downstairs for it. Yes.
But yes. Oh man, it's so fucking stupid.
I turn my camera on, but you don't want to see a guy with his shirt off, okay?
Well, you never know. I love some, tig old biddies, and if you got those, I'll look at them.
Yeah.
Hey, do me a favor. Sing and dance for a minute. I gotta hit the head real fast.
All right, go ahead. So let's get through. So that's like same with the braces, legal, illegal. Bob, let me go through some of this stuff, right? So Bob Masavo says we live in a country of the controlled and the yet to be controlled, and those wanting to control. That's well, I added those wanting to control, but that's what it is. DB Cooper says TMC absolutely disgusting. Yep. Too many choices, says meh. I don't give a damn. I don't give a frick anymore. Laugh out loud. He said technically you can do what the frick you want. They're just consequences. Yeah, well, I'm not fond of the consequences after. DB Cooper says alphabets don't follow laws, but expect us plebs to. That's for damn sure. That's for damn sure. They don't get warrants, but they go to people's houses trying to confiscate something that they didn't care about, 6 months prior, but since they made a decision, now it's illegal. So they need to go around and pick it up without a warrant. That shit should be illegal. You know, Bob Masava says all you need are your emotions to be hurt these days. Exactly. Lightning Scott says wrong pronoun. I'm not sure what the pronoun is. Too many choices says that's a freaking saber. No, that's a bayonet. That's a World War I bayonet. That's the one from the 1903. But it also fits the M1 Garand.
Well, maybe, yeah, because that's the M1 Garand.
Well, no.
So, yeah.
That bayonet it was originally for the 1903, and then they fitted it on the Garand.
So all I want to know from all you guys is if I made this glow in the dark, would I not look like a fucking hobbit?
It would have to, it would have to glow like a white silver, and it would have to be forged by elves.
Well, I'm not going through all that shit, so I'll paint it in chem light and do it one night.
And then we call you dark.
No, I'm not dark. Dark is way bigger than me. Well, according to his deck.
It's like Bob Masava was like, please spare us that night strike. Well, you know.
Sting, yes.
Yeah. M. Gabriel says, what bayonet is that? It's the one for the 1903, but it also fits the M1 Garand.
Yeah. This fits the M1 Garand.
If I had to give you the actual designation, I think it's like the M1913 bayonet.
Yes, I think so. This one's Chinesium, so
is mine. Mine's the same damn thing. But I got Mark Novak to fix it on camera anyways.
Yeah, this one is hard to see, but I got the China marks on it. So yeah, this is Chinesium. But still a fucking
wow. I don't want to read the rest of these comments.
This off the end of an M1 Garand, you could fucking pole vault with this thing.
Yeah, hold on. Give me.
He's putting his shirt on.
No. you that shirt, Jesus.
I'm wearing this shirt. Put a shirt on.
It's hot. It's like 83 fucking degrees here. No way.
I got a fan going right there. I'll show you my titties if you want, though.
No, here, right there. That's what it looks like when you have that bayonet on an M1 Garand.
Yeah, and you can't see a tape measure on that, but that gun's like 8 foot long, and the bayonet's like 4 foot long.
The bayonet is like half of the gun right there.
Yes.
Take that bayonet off and put it right underneath the edge of the barrel. It's half the size of the gun.
Yeah, if we could show guns off on stream, I got my M1 sitting right in there. I'd show it to you.
Yeah.
It's way taller than I am.
Bob says, pass around the collection plate for a Mancier for Night Strike. Thanks, Bob. Thanks.
Now, these guys all know you two already.
I know.
You do not expect the smart acidness.
I expect it. I expect it all day long, but they always surprise me with the comments.
Hold on to me, Choice. Damn it, I ain't got a tape measure near me, but I'm pretty sure it's over 72 inches long.
Yeah.
Not my pecker. That's not what we're talking about. Because if it was like that, I would show it to everybody.
Well, then Koopy better quit playing with it.
Dude, if it was like that, I'd play with it in a town square. I'd volunteer to be a fire pole in a firehouse. Just slide down this to get to your fucking ambulance. No.
But that's what I wanted to say about this whole thing, because I've been listening in on this, off and on all morning, and it's just like it's been fucking ridiculous. It's like these judges don't understand that the NFA infringes on the Second Amendment. It's like I need to go to the Library of Congress and print out what the 17th, 18th, 19th, and 20th century definitions of infringed means. And slap them with it.
So here's the question, and this is honest. You heard both cases today from the state and from the federal government, and then you heard the way that the federal judges question this. Where do you think it's going to land?
The federal judges are asshats, and they're going to say, "Well, you don't have enough leg to stand on, so we're sending this back," and they're going to deny it.
See, I'm half and half. I think
if they do that, then that gives them precedence to go and send it straight to the Supreme.
I'm half and half, believe it or not. I think, judging by the questions that got asked today, because there were a couple of judges that absolutely smoked the dude from the federal government. I think there's two things that can happen. One, they can say, no, we're not ruling on this because it doesn't have standing. The other thing I think that'll happen is that they actually side with Texas. Remember, we're talking about the 5th. If we were in the 7th, I'd be like, we're fucked. But we're in the 5th. And just judging by the questions that they asked and how they presented information, we have a better than even chance of actually winning this case. Now, does it go to the Supremes after that? Oh, yeah. Because if we win, the federal government's going to appeal this shit, and then, yeah, we're headed. We're up there.
Yeah, well, the problem is I'm in the 4th Circuit. And
I know, you poor bastard. I'm in the 11th.
Normally, the 4th Circuit wouldn't be so bad if for one fucking state and one district, and you know what that state is.
Oh, what state is that? Tell us all.
The state of Virginia and the District of Columbia.
Yes. Yes.
Otherwise, the 4th Circuit would be fine.
The 4th Circuit would be fucking great if it wasn't for them. And for those of you who don't know,
and Maryland.
Let me pull up a district circuit or a circuit map.
Maryland, Virginia, and the District of Columbia, basically.
I think this will do it. And there's a difference in between district and federal, so don't hang me on this one. Hold on, we gotta do a screen share. Da, 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 da. We gotta play Hunter Got High before we get out of here.
I went and watched that the other day. I was like, oh wow, he made a sequel.
Hold on, where's the fucking tab I had open? Google search. Is it this one? Yeah, this is this one. And trying to figure this out. This is a new computer. I'm still trying to figure shit out. And this one ain't touchscreen. So what you'll see, Night Strike, you sit in the 4th. I'm in the 11th court. The 5th Circuit.
That's because you're special.
Yeah, we are special.
Special.
5th Circuit, the case that was argued today is in Texas, Louisiana, and Mississippi.
Now, the funny thing
is, the 7th Circuit is its own special fucking case.
I'm originally from Arizona, so guess what circuit court I'm originally I would have to deal with if I was still in Arizona.
Oh, in Arizona, you'd be the 9th, wouldn't you?
It would be the 9th Circus.
Yes, it would be the 9th Circus.
Yes, because remember, kids, the 9th Circuit Court of Appeals is nicknamed the 9th Circus for a reason.
For an absolute reason. It's not even a joke at this point.
It's not a joke.
It's a fucking reason.
There's a reason. We say it like it's a joke, but unfortunately it's not a joke because of the idiots that are sitting in chairs there.
That's a laugh so you don't cry situation.
No, you're still crying no matter what.
Well, that's why I've got comedy and tragedy tattooed on my chest. And whoever
I thought that would have been your tramp stamp.
This is one of my biggest bitches. Okay, if you see like a happy face and sad face, tattooed on somebody, and you go, "Hey, that's happy and sad," you're a fucking idiot. That's comedy and tragedy. Come on, get with the fucking times. It's only been there since 100 BC.
The times are, happiness and tragedy. Oh my.
Yeah, y'all just got Flash.
Yeah, you don't have as much chest hair as I do, though.
No, you're a fucking Wookiee.
This is true.
It's, people don't want to realize he's got royalties from Star Wars coming in.
I wish.
Hey, look, if I could get him as my little hobbit ass, yeah, I'd be a fucking Ewok. Fucking jabba jabba. Stabbing some bitch in the head. Yeah.
Nub nub.
Yeah, nub nub. Nub nub.
Oh boy.
Another reason I love you so much, Knight, because you get the shit. Oh yeah. Yeah. If I was on Star Wars and freaking Night Strike was on Star Wars, Night Strike would be the Wookiee, I'd be the fucking Ewok. My short ass. He'd be I'd be like, yam nabba. Stacking some bitch over a fucking candy bar. Nabba nabba.
That's exactly right. We needed this after today.
After today, yes, we needed this shit. You can't let my sense of humor out on its leash.
What leash?
You can't.
I thought it was free roam.
No. He's still tied to the stake. Trust me, because if he wasn't tied to that, we would have gone a whole lot of other places.
It's free roam, like the chickens out in your backyard.
No, I've only got one chicken left. The fucking owls and shit killed the rest of them.
Well, stop petting those possums, and maybe you can keep some chickens.
Funny enough, the possums are probably the biggest killer of the chickens that I've had.
They're doing that because you keep on petting them and treating them like cats.
I never.
That's their revenge.
Being as country as I am, I never would have realized that possums would kill more chickens than foxes or raccoons or owls or anything like that. Fucking possums.
Well, there's not a lot of foxes around these days because of all the hunting.
Oh yeah, well, dude, we got a bunch. We've caught some on game cams. I've caught bobcats on game cams.
Let me put it this way. They're not as common as they used to be.
Depends on where you're at. That's like people talk about coyotes. I know that
coyotes are everywhere because the wolves are only in a small portion of the country these days because they reintroduced them. They're not doing so great. And the problem is the coyotes bred and spread like wildfire because there's no wolves. So the coyotes took over that job because they did it anyways.
It's always working off that hierarchy.
You know what? To bring Star Wars back around, okay? Remember the phrase, there's always a bigger fish. And that's true in nature.
Hey, fuck Star Wars at this point. If you want to listen to something that's like Star Wars related, that's actually really goddamn good and hadn't pushed out yet, listen to Galaxy's Edge. Galaxy's Edge. I went back through and listened to their main series of books in the last couple days. Jesus Christ, those books are so much fucking better. It's like having Darth Vader that actually has balls. It's like having Luke Skywalker that didn't get his nuts chopped off. It's like having fucking R2-D2 that's a little homicidal maniac. It's fucking great.
R2-D2 was.
Yeah, well, this one actually like lets his balls roll on the outside of his shell.
Okay, all right.
Yeah, Galaxy's Edge, Jesus Christ, man. And you'll listen to it, and it's like, this is a complete ripoff of Star Wars. And it's like, that's exactly what it's supposed to be, is a ripoff of Star Wars, but with balls.
So was Rebel Moon.
What's intended.
Rebel Moon was supposed to be that too. And honestly, Rebel Moon was fucking boring.
I haven't watched it yet.
I didn't like
I haven't watched. Have you watched it? What you said something earlier. Have you watched the Fallout yet?
Oh, I've seen the whole thing.
You said it earlier.
I'm a big Fallout fan. I played all the games. I still play all the games.
Dude, I'd love Fallout.
Okay. If you love Fallout, here's what I'm going to tell you. Go back and play New Vegas.
I hated New Vegas, though.
New Vegas was probably better than 3.
How dare you speak that heresy on my channel?
I liked Fallout 4 a bit more than I liked Fallout 3. I'll tell you that.
That is heresy.
And I also like the one people don't like. I like Fallout 76.
I haven't played 76. I never have.
Let me ask you this. Are you a John Denver fan?
Country Roads. Yeah, I could do it.
Country Roads is the theme song for 76.
Yeah, I know.
It takes place in West Virginia, so, and I can sing the song too, and it mostly because my grandfather was from West Virginia. Anyways, that's neither here nor there. My grandfather's family were colonists, so it was Virginia before it was West Virginia.
You do have that right. But now, as far as Fallouts, I got into Fallout when Fallout 3 came out. As soon as it hit the Xbox, I got it.
Yeah.
And if you were playing in third person, the graphics were really screwy. Because it looked like you were running over a crowd.
I'm going to tell you right now. Fallout 3 was better on the PC. I played it on the console, better on the PC. Fallout New Vegas, better on the PC. Fallout 4 and 76, better on the PC.
Dude, the thing that pissed me off about, well, there were a couple things that pissed me off about Fallout 4. The amount of freaking not charge packs, the amount of power cells you had to get for the armor. There were a few things that pissed me off about Fallout 4, but I loved 3, and 4 was still pretty good.
It's why you play the PC version, and then if you don't want to play by the books, you just give yourself a couple fusion cores and play the game.
Oh shit, man! That's one thing that Fallout 4 had on the Xbox is you could download mods for it.
You can do that for the PC too.
Well, I know they can do it much easier on the PC.
Yeah,
much easier on the PC. Yeah. But I seriously got into Fallout when it came on 3. I may have played Vegas too close to when I played 3 so hard. So it may have got a little boring.
Honestly, go back and if you can, replay New Vegas. You may like it.
I need to, because like I said, I may have played it too close to when I got done with 3. Because I played 3 endlessly. And then New Vegas came out. I jumped into New Vegas.
I'm right now going through a playthrough of 3. I'm almost done with everything and all the DLC. And then I'm going to do New Vegas, and then I'm going to do 4. And then I'm going to do the new DLC that they did for Fallout 76.
See, and I've never played 76. I wanted 76, and then when they said it was online and all this other horse shit, I was like, I'm not even trying it.
They fixed a lot of the problems from the original release.
Yeah, after the first, 2 years?
Yeah, they fixed a lot of the problems, okay? And honestly, I enjoy it. I wouldn't mind having a group of 3 or 4 other people go with me so that we could go through some of the dungeons, because some of the dungeons in that game is oh my God, you cannot do that with a single man with only 1,000 rounds of 5mm and a minigun. It goes fast.
Can you cross play on 76? In between computer and Xbox and all that?
I don't know. I think you can. I'm not. I will look it up. I'll let you know.
Look it up and let me know, because if we can do it, hell, we'll run it. We'll fucking stream that shit one night just to fuck off. Just because it's different than the normal horse shit that I do. Because I wouldn't mind doing a couple of gaming streams every now and then. Matter of fact, just to mention it, the guys from Wargate Books, Nick Cole, does a stream, I think, every Friday night, where they play Call of Duty or play another game. And I haven't been in it yet. I haven't done it yet. So don't quote me on it. But if you can find those guys and actually kill them during the stream, they give you free books or free audio books or something like that. It's cool as shit.
Okay, there's no crossplay. I just looked it up.
Oh, there's no crossplay?
No.
That sucks, because I don't have a huge computer I can play fucking Fallout on.
But there is a way around that.
I spend more money on shit that goes bang than I do computers.
There is a way around that. You've heard of Xbox Live Game Pass, right?
I know Xbox Live.
Well, they've got a thing called Game Pass, and they have it for the PC where you could just all you do is just to connect your controller to your computer, and then you just play it you played off
Yeah,
of there.
which-
You basically stream it more or less.
it was cool when I can't remember which Call of Duty it was, came out where you could cross play between all platforms.
Yeah.
Um,
Some games
What
do
you-
it, some games don't. That's the problem.
yeah. What you ran into there is that some platforms have smoother and faster controls than others. And there was a great channel that did some examples of it. And it's like turning on an Xbox controller and you're like turning in slow motion, and turning on the
Keyboard
the
and mouse.
computer and mouse, and it's like pow, and you were there. And that that led into
That's
some
why I
like
switched to computer gaming from console gaming years ago, because you get more. It's easier for you to respond faster with a keyboard and mouse, than
Yeah.
it is with a controller, because you don't have to. You don't have to dick with the control sticks. It's just
Yes.
tap, move the mouse. You're done.
And that one of these days, within I don't know, the next couple of years, I'm going to get me a PC where I can game on PC and get into some stuff. But
Yeah.
in my entire, I've been into gaming forever, ever since I was a kid, since the first fucking Nintendo NES.
You've been around since Pong.
I have been around since then, but I didn't get into like gaming hard until the Nintendo NES came out, and it was the original Mario Brothers.
Yeah.
And then we'd stay up for like 24 fucking hours straight playing that. I didn't get into online gaming until I'd been to prison and just got out.
Yeah.
And a
Don't
buddy
tell
of
people
mine-
that.
I tell them that all the time. This is too late.
So we were
But
seeing
I
your
got-
prison tats then.
I don't have any of those. I never got any while I was in. Every tat I've got, this whole chest piece, I got out way after I got out.
I mean, I've only got one.
Yeah, but that's your mom heart on your ass.
Hey, don't you say anything bad about my mom.
But no, I got into the original. I think the original game that I started to play online was Men of Valor on the original Xbox,
Oh yeah.
and that was a freaking good time.
Yeah.
Matter of fact, guys that I gamed with on that game, we gamed with all through Men of Valor, the next Ghost Recon, all the way through freaking Rainbow Six Vegas, all the way through like Call of Duty 3.
Yeah,
We were all always.
I've got
gaming
friends I
together.
still play games with occasionally that we went through almost every single Battlefield game together
Yeah.
as a squad.
See, I played the first couple original Battlefields where
Battlefield
I could, like, hijack
1942,
helicopters and shit
Battlefield
like
Vietnam, Battlefield 2, Battlefield 3,
that. I
Battlefield
think I was
4,
in Battlefield 2.
and 5.
I think I got into it as Battlefield 2. Because
And then-
I do love games.
And then I got us
really
into
love
Titanfall, and apparently they like Titanfall more than they like Battlefield.
It's funny how sometimes it changes.
Well, giant robot, team deathmatch, or just normal team deathmatch.
Oh,
The,
dude,
gi-
hold
the
on.
giant robots make things better.
As long as you don't play normal team deathmatch, you're not gay. As long as it's hardcore team deathmatch, you're good.
Uh-oh. I heard that, Coop. Fuck you. Yeah, anyways, guys, we're goofing off now. Sorry about that, though. Thank you. For those of you that are still with us, thank you.
Yeah, this is nothing but goof off after the freaking pain.
This is the normal conversations we have. I mean,
Yeah,
our,
dude,
our phone conversations are 10 times worse than this.
Dude, if there wasn't idiots who believed in gun control and stripping of us of all of our rights These are the conversations I would have every single day.
Well,
However,
Coop, I hate to be the bearer of bad news, but I think we do.
well, we still do, but I have a lot of these conversations too. And I want to get rid of these conversations and just pick on someone for being gay on Xbox.
Well, you're gay for just being on Xbox. I'm just saying.
Hey. I only blew that dude once and I didn't like it.
Didn't matter. You're still on your knees.
Yeah, but I only did it once and I figured out I didn't like it. So therefore,
That doesn't
I'm not
matter.
gay.
You did it.
I proved the theory. You just haven't done it yet.
Theory, Schmary.
See? That's what I'm saying. I proved it. You haven't proved it yet.
I'm not going to.
I mean, I like gagged and spit and got away from the dude. You haven't.
We got a question here for you, Coop. Martin Fink says, Coop, are you going to do a stream on the House passing the anti-Semite bill that basically makes criticism of Israel anti-Semitic?
Yeah, I'm going to when I get around to it, because anybody who has followed me very long,
We're the Republicans.
should know I am 100%. Well, they're the ones voting for this shit.
No. See, because Republicans are supposed to have balls. Where are the fucking Republicans? They're just letting the Democrats get any shit through, no matter what.
Well, there are a lot of Republicans that are the ones that are pushing this.
The Republicans should be against this kind of shit. They should be against gun control, but we keep getting hosed by both parties, and it's like, what the fuck? Does it matter what political affiliation if you're gonna go out, if you're gonna fist us up the ass either way?
Dude, we have completely flipped. Because it used to be Democrats, liberals, leftists were all about free speech. Say what you want to say. You had the ACLU,
they were also all about
American
guns too.
Civil Liberties Union, who defended the KKK marching through Jewish neighborhoods. They did that. That is fucking history. And then at the same time, you had Republicans saying, no, they can't do that. That's where that lawsuit came from. Now we've flipped the script to where Republicans are saying, no, you can't say that. And then you have Democrats supporting people tearing apart college campuses and rooting for the Palestinians. It's just, we are upside fucking down.
And all those people rooting for Palestinians, if they went over there, the Palestinians would shoot them in the head or hold them hostage.
Yes, or throw them off a bridge or a building. Or
well, that's only if they're gay.
The gays for Palestine shit, fucking I find that hysterical.
Yeah, the Palestinians would throw them off a building or collapse a wall on them.
Yes, or stone them to death. One of the three.
No,
so I find that
stoning's for adultism.
Oh no, they will do it for being gay too. Trust me. I do a lot of research. I've seen a lot of rocks thrown. Let's put it that way.
Well, have you thought that they just do that because you're ugly?
Hey, look, that was only spitballs, not rocks.
Oh, okay, all right.
And yes, I know I'm ugly. I've dealt with this shit my entire life.
Okay, all right. As long as you know.
Jesus Christ, if I was a pimp, you realize how much I could have been pulling when I was in my teens?
Ugh. I don't want to know.
I'm not saying they were pretty. I'm just saying I could have been pulling it. Instead, I just pulled it. Like you haven't. Say you ain't.
I don't want to finish that conversation. I think we're done here.
This is when you let my sense of humor out on its own.
Yeah, I know. You should have that thing leashed, but no, as I said, you've got it free roam.
No, my wife knows my sense of humor. I explained it to her one time. It's like midgets on chainsaws. And they just run around and chop down whatever they want. And funny enough, I almost got run over by a fat chick on a scooter one morning, not too long after I explained that to her.
You and your midgets with assless chaps.
Hey, not all their chaps are assless. Not all of them, most of them, but not all of them.
So that makes it any better?
There are some that wearing thongs. Technically, those aren't assless.
Ooh, that's. I, I don't want to picture that.
Yeah, you do, and you're already doing it because you
No.
think like I do in pictures, you motherfucker.
Hold on, let me get AI on this.
Yeah, that's why I don't have too many. That's why I don't have too many conversations with AI. Hey, AI, what? Draw me a picture of a midget with a pogo stick,
Oh boy.
dildo handle. Just saying.
Oh boy.
Hey, look, I never said I was sane. I've never said that on a single one of my streams.
I never said you were either.
No, you've never accused me of that heresy, and I'll give you the credit for that. Jesus fucking Christ, man. It's
Hey,
just,
we have fun while we do it.
hey, you might as well, man. The amount of shit we put up with every single day, just being the normal gunner, if you're paying attention, the amount of shit you put up with every day, fucking have fun with this shit at this point, man. Make a whole lot of really bad jokes, make some goddamn dogs gag, do something. Hold on, I should have rephrased that last part a little different. But either way,
That's what she said.
If she makes a dog gag, I hate to see where her cat's at. I'm just saying.
But wouldn't you like to know?
But no, it's just there's just so much stupid shit going on right now. When honestly and truly, and this is the honest, true fact of it. As long as I don't deprive someone else wrongfully of life, liberty, or property, then the government shouldn't even be involved. And if someone thinks I wrongfully deprived them, say if my house is pink and their house is white and whatever, and they think I'm depriving their property value, that's what civil court's for.
You are depriving me of one thing.
Sanity.
Yes, you're goddamn right. That's exactly what I was gonna say.
Well, welcome to my stream, motherfucker. You've been here long enough. You already know.
I already know, and I keep coming back. So
Yeah,
there's no hope for me.
So yeah, there's no hope for you, brother. None at all.
We do have a comment out there from Barton Fink saying Coop getting a 70-inch 3D 8K TV for full-size midget porn was when I became a subscriber.
Hey, don't tempt me into a fucking midget porn stream one night because we'll goddamn do it. Bridget the midget will look like she's 9 foot tall in your living room if you have a big enough TV.
Wow.
Yeah, that's a big ass TV because that chick's like fucking what, 3 foot something?
Yeah.
Yeah, that's a big TV. Just saying, I'll do it. I am amazed my channel on YouTube has lasted this long.
You're not the only one. I'm pretty amazed by it myself.
Oh, I am. Every morning I wake up and I look at my YouTube channel. I'm like, that motherfucker's still there.
Yeah, I know. I do too. That motherfucker's still there and he's live. What the fuck?
Yes. So I am amazed. 40 midget porn. Where can we get that, Bob? Because I would do it in her. Just being honest here. You guys know me. I say what I want to say. Can we get the freaking like virtual reality goggles for that?
You would have to.
Ask Dark.
Ask Dark.
Hey, look, Dark is just worried about big decks, not midgets. My wife has a 60-incher. Damn.
Wow, her boyfriend must be hung.
Gabriel, what are you doing?
No,
Maybe
no,
you're like me.
You ask you what, Gabriel, what are you watching?
Well, it could be like me. I realize I'm hung like a stud gerbil, so I just eat pussy like a king.
No, see, that's only if John and Dark and Rich are around. That's the only time we talk about decks.
Midgets with big dicks.
That's a John Crump, Dark, and Flying Rich joke.
Yeah, absolutely.
They're totally into people's decks.
You guys are just as screwed up as I am, and I love every one of you. I love you guys so much, it ain't even funny. It's seriously not even funny. No gay, but just funny. Funny, haha. Much like I love Night Strike. It's funny, haha. Although I still got to get with Night Strike, I got to get with Knight, a couple of the guys he knows, and do some serious gun work.
Yeah, you do.
Because freaking.
So do I. Because I that G3 I gotta tear that muscle brake off, and it looks like I may have to cut it off because I cannot find any parts on it where they used they pin and welded it. I tried heating it up to see if I could twist it off. It won't twist off.
No. If it's a pinion weld, you're gonna have to drill the pin out.
I looked, I couldn't find a pin and weld on it.
You couldn't find the pin?
There's no pin and weld on the muscle brake.
Grind it down, and this sounds like it probably is absolutely retarded, but grind it down and acid etch it and see if you can figure out where the pin's at. When you figure out where the pin's at, you can drill the pin out, and then you can pull it. Don't grind the barrel, grind the muzzle.
I was thinking about doing something completely ridiculous.
What, like chopping it off and then rethreading it?
No, even worse.
Oh, God. What are you thinking then? Because that's a tragedy. What are you thinking?
Cut and wheel on the Dremel.
I love you, Night Strike, but Jesus Christ, you're a nightmare. I mean, you're talking to the person who you like.
Well, hold on. Before you say something, even Mark Novak uses a Dremel.
Hey, I know he does, but he uses it sparingly.
Yeah, I know, but I'm actually, believe it or not, I'm actually pretty damn precise with the Dremel. It's just, as I said, I cannot find a pin. So I don't know if it's been welded or if it's been, epoxied on. And the only way I can figure that out is literally if I Dremel the damn thing off.
No, there's two ways to figure that out. If you can heat it up to where it's red hot and you can't spin it off.
I did heat it to red hot.
Okay, then it is pinned. You can grind it down. You can take a sanding drum on a Dremel and just on the muzzle device itself, sand it down. And then you can acid etch it, whether you use vinegar or whatever else, that will show you the difference in between the two materials, and that will show you the pin. And if my wife's still in here, she could tell you better because she's dealt with this shit before a lot more than me.
I've also been doing some other things to it to try and find the pin. I've even tried using a file.
Yeah, but a file just think about files. Okay, so a file will tend to smear metal around.
No. Honda gunsmithing is much worse. Trust me.
Yeah, I got to look them up. But yeah, if they're much worse, oh shit. I really do need another drink.
So do I. So with that, I'll see you guys later. Take it easy.
Nice Strike. Take it easy, my brother. Get out of here. I'm fixing to get out of here.
Just end it right now so we can go do something else.
No, because you're going to leave. I'm going to talk shit for a minute, and then I'm going to get out of here.
I'll wait for you to talk shit then.
Oh, shit. Now I'm on fucking deck. Oh, shit. Thank all you guys for hanging out for the stream, for listening to oral arguments, because you guys know anytime there's oral arguments come up, we are going to try to post them. We're going to try to listen to them. We're going to talk about them. Fluffy Bunny, what's up, my brother?
I gotta address Barton Fink's comment. The problem is, Coop doesn't have a safe word.
No, I don't. I just drop a golf ball. And as long as I don't drop that golf ball, you can be as mean to me as you want.
I've tried the sock on the doorknob. I've tried banana. Just he doesn't have a safe word.
No, there's no such thing as a safe word. Like I said, I got a golf ball, and as long as I don't drop the golf ball, we can keep on running. And the problem is with the golf ball, I'm like a monkey trying to pull a freaking apple out of a trap. I never drop the golf ball.
I thought it was a golf ball and a garden hose.
I don't suck that hard. No, I definitely don't suck that hard. My channel might, but I don't. Now, my channel might be able to suck a golf ball through a garden hose or a fucking softball through, or maybe a bowling ball, but I don't, personally. Yeah. Mine is, I just hold the golf ball. And as long as I don't drop the golf ball, we're good. Plenty of punishment involved in that.
Yeah.
Heard a pineapple was involved. Hey, only inserted in the wrong direction. Just saying.
You can't make this shit up, I'm telling you.
When you insert it with the smooth side, and then it hurts more when you yank it out. So I'd much rather take the pain in the first place. The way it didn't feel as bad getting pulled out. I'm all about optimism here, kids. Didn't you know that? This is the only thing I've said that's ever made Night Strike go quiet.
No, I was reading something. I got an email. I was reading an email.
Oh, that's what you blame it on.
Well, if you want to know, somehow Dudley Brown got a hold of my email address, and I'm reading what the shit he's saying.
Oh, well, shit! Just answer that.
I can't be like John Crump and just like completely humiliate him on YouTube live.
Well, you could be.
I was watching that. That was great. By the way, he got real pissed and he left.
I don't remember that exact one, but I could see it happening.
I didn't like it. It was great.
All I gotta say, if you guys email me, I will not completely humiliate you on a live unless you're an absolute gun control tyrant, and then I'm gonna put your name out there.
Or it's me.
Well, you jump on the stream to be humiliated because Jesus Christ, it's my stream.
Yeah, I know.
You sign on for humiliation.
Gabriel.
Gabriel's a fucking nut. I love him.
Oh, I love that. That's great.
Hey,
that's perfect.
If I took any shorter strokes, I wouldn't be able to move more than about a half an inch. I'm just saying. Like a stud gerbil.
A stuck gerbil, you mean?
No, stud.
I don't think gerbils can be studs. I think you have to be a horse to be a stud.
Have you ever looked at the pecker on a gerbil?
It's non-existent.
Yeah, well, that's why I'm a stud, because I actually have one. You can't argue with that logic.
Someone's got deck envy.
You guys kill me. All right, I am going to end this, though.
Yep.
I'm going to catch a nap before the wife and kiddos get home.
Good luck.
Yeah. Last time I tried that, I got 47 phone calls in about 37 emails. So,
And if you don't
yeah.
answer those when she gets home, oh boy.
Oh no, it ain't just from her. It's work and everything else. I tried to catch me a little bit of snooze last night, or yesterday afternoon, before I had to pick my daughter up and go do all the dad stuff. Yeah, that didn't work out worth a shit.
It never does.
No, it never does. It never will. So anyway, all you MVs in the chat, I love all you guys to death. All you perps, keep that thing on you at all times, because God knows you're going to fucking need it at one point in time or another. I love all you guys. And that's serious, man. I do. I love all you guys. Be cool. I still want to darts lines. Be kind. I'll rob it a little bit. Keep that thing on you at all times. And realize, dude, we got some really freaking screwy times coming up. So you guys take care of the fam. Take care of yourself. Take care of the ones that are close to you. I love all you guys. I'm out. Me and Nice
Shut
Strike.
up, infringed.
Nice Strike. Yeah, Nice Strike. Say it again.
Shut up, infringed.
There you go. Shall not be infringed, motherfuckers. And we are out.